mentioned for item number 54. My lord, in this case, my lord, the employee of Assam Rifles was transferred from Shillong to Manipur my lord, has transferred this petition here, my lord. My lord, he wants to file a petition before Shillong court. Therefore, he wants to withdraw it.
The request of Mr. A.R. Sikdar, matter stands dismissed on withdrawal, as it is submitted that the writ petitioner seeks to withdraw writ petition and seeking liberty to file afresh before appropriate forum. Writ petition dismissed with liberty. Interim orders, if any, stands vacated.
May I please, Your Honor?
Mr. Who was appearing in the other side? Mr. Rodhikari. Rema Rodhikari appears for the respondents. Yes.
I'm praying for listing this writ petition, my lord. Transfer matter, my lord, can be taken up tomorrow, my lord.
Tomorrow. Tomorrow not possible. We can have it day after.
Bless me.
21st, yes.
May I pray your lordship for listing in the admission column? Finance department has not on 1st of March, lordship.
1st of March.
Lordship.
All right, 1st of March.
Yes. Finance department has not filed as well.
May I please, Your Lordship? Lordship, I am making this pray on behalf of Mr. P.K. Tiwari. I beg to mention item number 12 of today's list. Kindly be adjourned for a week.
Item 12, at the prayer of Mr.
Ajay Das.
R.J. Das, Learned Counsel, appearing on behalf of Mr. P.K. Tiwari, Learned Senior Counsel, matter stands adjourned for 2 weeks.
Deeply obliged.
Please, Your Lordship. Lordship, I beg to mention item number 17. With the consent of the other side, Lordship, we are required to file affidavit in reply. Lordship may grant 10 days time to file our affidavit.
Learned Counsel appearing for the petitioner with the consent of the counsels for the respondent submits prays for 2 weeks time to file reply affidavit.
Lordship may
Prayer
fix the
not
date.
objected to by the respondents, matter stands adjourned for 2 weeks.
Obliged.
May it please your lordship. Lordship, I am praying for listing of this matter in the admission column, lordship. Matter relates to non-payment of arrears salary, lord.
Arrears salary. Let's have it on 4th, 4th of March.
Obliged.
May I please the lordship? Lordship, I am praying for the listing of the WPC number 2646 of 23
Why?
for admission. Lordship, the matter, since this matter relates to non-payment of fixed pay from 2001.
Right, 4th of March.
Obliged, Lordship.
May I please, Your Lord? Lordship, I beg to mention item number 18, my lord. So,
18.
Lordship, kindly adjourn the matter for today, my lord.
You are making on behalf of
Of BK Das.
item 18 at the prayer of the counsel for the petitioner, matter stands adjourned for 1 week. 2 weeks.
Like, my lord.
May it please, my lord, I beg to mention item number 13, my lord. Release this. My lord, the conducting counsel, Mr. P.D. Nair, is out of session, my lord.
Item 13 at the request of
I've taken
the prayer
consent
made
of
on
the
behalf of Mr. P.D. Nair, matter stands. Counsel for the petitioner, matter stands adjourned for 2 weeks. No objection by the respondent counsels.
My lord, next week, if it pleases, my lord.
Next week, we pray for an adjournment, it goes for 2 weeks.
My lord, Mr. Nair won't be there on 5th, 6th, and 7th of March.
Then we'll have it after 3 weeks. 3 weeks.
My lord.
Yes.
It please your lordship. Your lordship, a prayer for listing of writ petition for admission column be kindly be allowed on 22 February.
We'll go to March. What is the matter about?
Your lordship, this regarding suspension for
4th of March. Have it on 4th of March. Yes.
May I please, your lordship, for listing the suspension matter, lordship, the department has issued that.
Fourth. 4th March.
Friday,
4th March.
May I please your lordship? A matter relating to payment of arrears salary is pending. Kindly fix the matter for admission on 27th of
4th of March.
Lordship, I beg to mention item number 1.
1. Wait. Let it be called up. Yes. You wait. Let the matter be called up. Yes.
Please, Lordship. Lordship, I beg to mention for an urgent listing of a writ petition 2015 matter.
What is the matter?
Lordship, it's a matter pertaining to termination from service. And while pending adjudication from this court, the petitioner is nearing the retirement on 31st of March.
Fresh petition,
No, Lordship. It's a 2015 matter, writ petition.
then let it be on 4th March.
4th of March, Lordship.
My lord, I prayed for listing of a writ petition on 4th of March, my lord, matter relates to non-payment of pension. Published.
Lordship, I beg to mention one writ petition to be listed on 21
It'll go to March.
March.
11 March.
May I please, Your Lordship? My lord, I beg to mention item number 51 and 52. I have been recently engaged in this matters. So I need some accommodation.
51, 52
52.
is a
My
part
friend-
heard matters.
Yes, my lord. Recently I have filed my wakalatnama.
Uh,
I have been engaged recently.
Mr.
the respondent.
A. Dhor, learned counsel for the petitioner.
Respondents, my lord.
It's for the respondents. Respondents.
Respondents.
Okay. Any objection, Mr. For the refinery?
For the refinery.
Mr. A. Dhor, learned counsel, submits that he's been recently engaged on behalf of the respondents. He seeks further time to complete his instructions. Mr. P. Mohanto, learned counsel for the petitioner.
Item 51.
In item 51, does not object to the prayer made.
51, 52, both are connected probably.
No,
Well,
he is appearing for 51.
I'm appearing for 51.
You are appearing for both, he is
Both.
appearing for only 51.
I have a prayer for both the matters.
Yes, yes. We are only recording his presence for 51.
Fine.
Matter be listed,
On a hearing day, perhaps my lordship may like date convenient to your lordship.
7th. 7th.
12th or 14th any day. This week I will be out of it. 12th or 14th.
We can't say that.
7th November.
More bundle, yeah.
You are not available in the first week of March.
No.
Then, all right,
Has to go
12th.
to 19th.
Hmm? 19th, we don't know. Just fix it, yes, 19th.
19th. Obliged.
Deeply obliged.
Petitioner not available.
Yes, my lord.
They filed some additional affidavit. Have you?
They have filed additional affidavit.
Right.
My lord may issue notice at least.
Okay. But they're referring to the orders of another coordinate bench.
Yes, my lord. Case 58.
Is it covered by that matter? By that order?
In this particular case, my lord, direction was issued to the respondent to verify the claim if they entitled, then to pass
All
consequential
right,
order.
heard learned counsel to the parties issue notice returnable 4 weeks. Mr. N.J. Katonier, standing counsel, education elementary, accepts notice on behalf of the elementary education department. Mr. R. Borbuzari for the finance department. And
Respondent number 3, my lord.
respondent 3. Since learned standing counsels have entered appearances, notices are waived. However, extra copies be furnished within a period of 1 week from today. As per the last order,
This is question.
the petitioners, as per earlier orders, petitioners were directed to file the additional affidavit, which have since been filed and is available in the case reports. Copy of the additional affidavit be also furnished. List after 4 weeks. Your name, please.
C. Roy.
C. Roy appears for the petitioner.
Well, Lordship, in this case, we are supposed to receive instruction, Lordship, on behalf of
My
the.
father expired, but.
No, Lordship, let it be fixed on Friday. I will ensure, Lordship.
Friday, all right. Friday, but.
Friday.
Or Thursday also, Lordship. It can be Thursday or Friday. Any.
All right, Friday,
Obliged, my lord.
Friday. At the request of CDC, Mr. Paranto Magistans. Adjourn to Friday. Yes,
Instruction was called for later.
instructions.
Basically, it's a PND matter, Lordship. Although on the last date, the PND did not appear, so senior,
You
yes.
inform the PRD department, whoever is there.
So senior government advocate was directed to provide the instruction. We have provided, communicate the order, Lordship.
You call for the, you inform the PNRD
Yes, sir.
standing council. Take it up after a while.
Obliged.
May I please your lordship? Lordship, here the demands of the. My lord, the demands of the petitioners are the petitioners were employees of the respondent number 3, my lord. Pursuant to the, my lord, ROP rules, my lord, 1990, their pay has been fixed at a stage which is lower than the total emoluments which they used to draw before the rules came into being, my lord. My lord, they are affected by the 11(2) of the rules, my lord. At page, my lord, 17, my lord, I have quoted the rules. My lord, this similar set of repetitions came up before this honorable court, but and the latest it came before this honorable court, which was disposed of, my lord, by this honorable court on, my lord, in page, annexure 5, page 47, the relevant order is at page 50, my lord. My lord, where the honorable court has directed the respondents to re-verify the issue with regard to their payments, my lord. The relevant portion at page 51, my lord. Different departments have been coming before this honorable court, but this from the respondent 3 department, it was on with regard to page number 51. And this covered with regard to this.
What do you say, madam? Yes,
Yes, Lordship. It is covered matter, Lordship.
page 50.
Yes, 50 and 51, Lordship.
Anything to submit from the finance?
Last. ROP rules 1990. Last page to.
Covered.
My lord, in fact,
You have a look, we'll
Yes, my
take it up after a while.
my lord.
Have a look. We are dismissing it.
No, my lord, it's a transfer brief, my lord. I have just entered, my lord. I will regularize everything by today itself.
Who was the council otherwise? Some earlier council.
Some earlier, someone others else not there. I just have to come to my notice that it's just
Mr.
listed for order, no steps.
You are for the petitioner.
I am for the. I'll do the needful by today itself.
Mr. Somua Learned Council submits that he has recently been engaged. How recent?
How recent this will not, I filed the Wakalatnama earlier, it was never listed after that.
Submits that through oversight, the steps required to be taken were not taken. He assures the court that the steps on respondents will be undertaken within the course of this week.
Course of the day.
Mr. C.K.S. Pura, Learned Council, Government Advocate. Respondents.
Respondent number 2, Lordship.
Respondent number 2. Mr. Borthakur for Public Health.
Respondent 1
1 and 3.
and 3.
Number 2, who guys said?
MS
No, it is.
K. Parasar for Respondent 4.
Oh, sorry.
Steps on Respondent 5 be affected by usual course registered post, Dusty is also permitted.
My lord, I'll do it. Because
List after 2 weeks.
I'm obliged.
May I please, my lord, in this matter, I pray for some time, my lord. I have to receive some instructions that with regard to their present status. My lord, the matter relates to non-payment of salary, my lord.
He must have received it by now. Yes.
Well, maybe they are subject to that screening process. They are from Dhemaji district and they are not getting.
2015 matter, you get your instructions.
In fact, my lord, we have filed our affidavit.
No, up
but
to date.
Maybe, my lord.
Up to date instructions, we'll have it on 27th.
Yes, my lord.
List on 27th, enabling the learned respective councils to complete their instructions in the matter.
Obliged.
May I please your lordship. My lord, the brief is taken by the petitioner on 5/3/2019, lordship.
What is taken?
Brief taken back from me, lordship.
Okay. Who is appearing now? Mr. R. Sharma, learned counsel appearing for the petitioner, submits that the brief has been returned back to the petitioner on
5/3/2019.
5/3/2019. Have you informed the registry? Have you filed any application before the registry for? Mr. Sharma will file appropriate application before the registry for striking out his name. Registry will thereafter take necessary steps for informing the petitioners. Anyone for the respondents?
Yes, lordship.
MSM Bhattacharya appears for respondent number 1, 2, 3. And A. Parasar appears for respondent number 4. List this matter after 4 weeks.
Thank you. Would this matter be taken after some time?
After some time.
In 8, I am the respondent number 5 and 6, my lord. And in 9, I am the 2 petitioners. Here, your lordship, it will be pertinent to look at the previous orders. In fact, the last order in both the cases.
It's a parity of pay.
My lord, parity is what is the issue involved in the first writ petition. We and the other writ petition, we are assailing a resolution of the development authority.
What order you want to refer to?
My lord, in my case, the respondent government.
What is your case? You're
That
appearing
is-
in both.
That is my me being the petitioner in the second case.
980.
Yes.
Yes.
In that, if your lordship kindly takes the last order, there, my lord, it was observed that it would be necessary for the government to file an affidavit. An instruction would be sought for. But till date, no affidavit seems to have been filed by the government.
Where is what order are you assailing?
My lord, here in this writ petition, I am assailing the board resolution that was adopted in the
Page number.
that board resolution, your lordship will kindly take up at page 73, my lord. Your lordship will take up page number 73, resolution number 3, which is impugned in this writ petition.
Please read.
Fresh decision as per High Court case number WPC 4037 of 2014. As per order dated 28/1/2015 of the Honorable Guwahati High Court, passed in WPC number 4037 of 2014. Date was fixed on 26/2/2015, 23/3/2015, and 13/5/2015 for hearing of the writ petitioner Sri so and so and so and so. And the chairman, by order dated 13/7/2015, referred the matter to the board meeting dated 23/11/2015, and accordingly, the matter was taken up for board decision as per agenda number 3, while meeting notice number so and so dated 16/11/2015, asking the writ petitioners to remain present in the meeting for discussion and decision in the matter. During discussion of agenda number 3, the writ petitioners personally remained present in the meeting but refused to take any part in the discussion hearing, stating that they submitted an application on 21/11/2015 for amendment of the agenda of the subject matter of discussion. The members present gone through the contents of the said letter dated 21/11/2015 of the writ petitioners and found the same is without any merit and accordingly rejected the same. The members present gone through the order of the Honorable High Court dated 28/1/2015 and also the resolution number 4 of the 71st board meeting. Both the writ petitioners holding the post of building inspectors having educational qualifications similarly matriculate, and both of them have no technical qualification. The reduction of higher scale of pay was necessitated because of that. The other similarly situated building inspectors and field assistants are not getting the equal scale of pay as enjoyed by the said Sri so and so and so and so. Moreover, the financial position of the Silchar Development Authority is not permitting payment of any higher pay scale. The monthly collection of revenue is much less than the fund required for payment of salaries to the employees of the authority as submitted by the accountant. Therefore, the members present unanimously decided that said Sri so and so and so and so shall be entitled to the same pay scale of pay of other building inspectors and field assistants similarly situated. Now, this was the resolution, my lord, and this has been assailed. In the
What was the earlier order?
My lord, earlier order, your lordship kindly sees at page 65.
Hmm.
It starts from page 65. My lord will kindly take up page 68. That is the relevant part. May I read, my lord? Page 68. Page 68, if your lordship has taken up. Without entering into the contentious issues raised by the parties, court is of the view that the impugned resolution has resulted in reduction of the pay of the petitioners, which they were enjoying for the last 10 years since 2004. Naturally, such reduction has entailed civil consequences and has adversely affected the rights of the petitioners in such circumstances. It was necessary for the authority of the Silchar Development Authority to have offered reasonable opportunity of hearing to the petitioners before taking the impugned decision. In a case of this nature, principles of natural justice are required to be followed, and failure to put the affected party on notice would vitiate the decision taken. Admittedly, in this case, no notice was issued to the petitioners and they were not heard before the impugned resolution was adopted. In such circumstances, the impugned resolution cannot be sustained. Accordingly, the impugned resolution number 4, dated 23/7/2014 of the Silchar Development Authority, pertaining to the petitioners are hereby set aside and quashed with liberty to the Silchar Development Authority to take fresh decision in the matter, but only after giving due notice and opportunity of hearing to the petitioners. The petition is accordingly allowed, but without any orders to quash. This was the earlier order of this honorable court.
What was the earlier resolution? Which was it?
Resolution, again, that is at page 52, my lord.
52. Yes.
It starts from page 52. Your lordship will kindly take up the resolution number 4, which was impugned. That is at page 55. Down below, resolution number 4, my lord, page 55.
Yes.
The chairman discussed the various demands of the Silchar Development Authority employees and workers unions, along with the prayer petition submitted by both building inspectors and the field assistants of Silchar Development Authority, and also the court direction of the building inspectors and field assistants for sanctioning time scale of pay in the higher scale. The meeting also reviews the financial position of the authority in details and has come to know that the monthly collection of revenue is much less than the fund required for payment of salary to the employees of Silchar Development Authority at present. The board unanimously expressed its inability to sanction time scale at present However, the effort is being made to enhance the collecting of revenue by means of creation of new avenues as decided in the meeting, and if the fund position improves, the board may consider the case of the petitioners. The meeting also discussed regarding the payment of enhanced pay of Sri so and so petitioners. Both are building inspectors of Silchar Development Authority, while order number so and so dated 21/5/2004 and reviews pros and cons and found that the said order was made not in conformity with the draft service rules. Moreover, the present financial position of the SDA is no way allowing payment of any enhanced rate of pay to Sri so and so and so and so, and accordingly, the meeting decided to obtain the comments of the financial advisor of the director's office, town and country planning dispute. In the meantime, the meeting decided that the payment of enhanced pay to so and so and so and so be kept in abeyance, and they may be paid same scale of pay of other building inspectors and field assistants similarly situated for the time being. Now, against this, my lord, there was the earlier round of litigation. In that, the order was passed by this honorable court. Subsequently, my lord, the order that has been passed is now assailed.
Yes, who's for the petitioner? Why did you file an application seeking amendment of the agenda?
Here, my lord, in so far as our application seeking amendment, the agendas which were taken into consideration, my lord, that if your lordship kindly sees, at page number 72, if your lordship kindly takes up.
72.
Page 72.
Yes.
May I read, my lord. This is to inform you that your good self asked us to remain present on 23/11/2015 in office for discussion and decision in respect of enhancement of pay scale. In this context, we may remind you that the Honorable Guwahati High Court, by its judgment dated 21/2015 in WPC number 4037 of 2014, was pleased to set aside the decision of the Culture Development Authority, whereby our pay scale was reduced. But in spite of such order, you did not restore our original pay scale till date. Therefore, subject of discussion ought not to be, not ought to have been enhancement. As such, subject of discussion should be amended. Secondly, on the correct subject of discussion, we would also be offered opportunities to submit our service records and views as per direction of the Honorable High Court. But you have fixed 23/11/2015 for discussion and decision. Under the circumstances above, we cordially pray to your good self to correct, amend the actual subject of discussion and provide us opportunity to submit our views and relevant records, and thereafter fix date for decision in the matter. So our basic contention was that this honorable court had set aside the earlier resolution whereby our scale of pay was reduced. So the agenda of this meeting ought not to have been enhancement of scale, because that was already set aside, and we were already, as per this honorable court's direction, directed to be restored in so far as our pay scale which we were getting. We were getting for 10 years, my lord. This is also another aspect of the matter. From 2004 to 2014.
Now, who's appearing for the other side?
My lord, I am in this writ petition. The other side is my learned friend appearing for Silchar Development Authority. They filed their affidavit. Government was directed on the previous occasions to file their affidavit in this case.
And in the first?
In the first
what is
case,
the subject matter of challenge there?
There, my lord, they have these 8 petitioners. They have come up seeking parity. And in case this writ petition is decided in our favor, so they are also seeking similar benefits out of this.
Yes, who's for the respondent?
Now, respondents, Silchar
State.
Development Authority has filed their affidavit. Government is yet to file, man.
Okay. Then matter be put up for admission hearing as the council submit that the proceedings are completed.
Well, state affidavit is yet to be filed.
We don't know. They don't file 2018 matters.
Well,
They don't file. We can take it up on 29th.
29th of February, my lord. Can it go to March if not otherwise inconvenient, my lord?
All right, 12th of March.
12th of March. Obliged.
For admission hearing.
Obliged.
My lord, fixed salary of the petitioner for 24 months, my lord, not paid, my lord. He was appointed as laboratory technician, my lord, under project, my lord, Assam University, my lord. It is a UGC sponsor, my lord, project. Molecular characterization of genetic diversity, etc., my lord.
Yes, Mr. Somoa.
My lord, I have written to the University Grants Commission for the instruction and this IIT, my lord. And so far as his due is concerned, my lord, if he has worked under the UGC sponsored scheme, he will be paid, my lord. There is no
So
problem.
that is the information you were supposed to get.
My lord, but
the past two
I'm
dates.
waiting since long, actually,
Who is supposed to give that information?
the UGC head office, my lord, New Delhi. Actually, what happened, my lord, nowadays the regional offices are closed all over India. So we have to rely upon, for everything, we have to rely upon the head office. That is the difficulty.
Where is the project being carried on?
Project was carried on in
Assam University.
Yes, my lord.
yes, Assam University.
Who represents Assam University?
Mr. Kyle.
There is Mr. KL. There were two orders. There is a last order to find out whether the project is still going on, subsisting. How is it that the UGC takes so much of time to get us this
But
information?
I have written twice, my lord, as per my note office here in my filing note.
What has the UGC got to do in respect of these projects? Do they finance? Do they provide finance?
Yes, they funded the projects
Hmm.
and it was executed in an university or in a college. It is a sponsored program. And this person was, according to the petitions, this person was appointed as a project assistant in the project. So he has to be paid from the fund only.
What is the status, Mr. Chauhan?
My lord, my term already, my lord, finished, my lord, on 31st March 2014. Thereafter, my lord, my lord, wrote several representations to the respondent, my lord. But since, my lord, no response.
Who is
my lord,
required to release your payments?
My lord, paragraph 5, I have stated, my lord, in paragraph 5. The certificate also provided, my lord, at the head of the department biotechnology, my lord. Page 18.
What is the total amount? 1,20,000.
Yes, 1,20,000.
Well, let's fix it on next week, Milad. I will come up with an instant. I will not file affidavit, I'll just place instant. Just 1,20,000, it should not be allowed to so suffer so.
Matter stands adjourned to 28th
28th of
February, on which date
Well,
Mr. A. Chamwa, learned standing counsel UGC, will apprise the court with regard to the
entitlement.
as to whether the project, namely so and so, is still subsisting and what is the duration of the project, as well as to the entitlement of the payment
Petitioner's
sought
salary.
by the petitioner. Stop. None, however, appears for the Assam University. Mr. Chauhan for the petitioner, list on 28th of February.
Well, listed on 1st of March. During these days, I will be in UGC only.
1st of March.
1st of March.
Yes, is it covered?
Lordship, may, right now, my lord, issue notice, Lordship.
Why?
I'll have to the instructions.
You take
As
instructions,
this,
we'll take it up
this
on,
set of
you
petitioners-
take instructions, we'll take it up on first. You serve extra copies. Third learned counsel for the parties, matter be listed on first, enabling the standing councils to apprise the court as to the submission made by the learned counsel for the petitioner that the issues raised in the present writ petition stands covered by an order passed in WPC 2444 of 2019, order dated 21st of 21/2/2022, passed in WPC 2444 of 2019. In order to facilitate the respondent counsels to obtain their instructions, extra copies be furnished by the learned counsel for the petitioner within 2 days, placed on 1st of February, 1st of March.
Milo, kindly pass over for the time being.
Pass over for the time being. We are passing it over for the day. We listed on some other day at the request of learned counsel for the petitioner matters
Bless you.
passed over for the day.
Reply sent to reply sent to
Yes, Finance Department.
We have filed a detailed affidavit. Well, that matter pertains to my lord.
Lordship, this matter
Realization of case.
is along with the demonstrators, Lordship. They are serving as graduate teachers, Lordship, and they are seeking parity with the demonstrators. There was an earlier round of litigation, Lordship, that in that litigation, Lordship,
No, the finance has filed an affidavit. Are you willing to file a reply? Do you want to file a reply, or we post the matter for admission hearing?
Lordship may dispose it of, it's a short matter, Lordship. Otherwise, Lordship, the expert committee that was constituted in terms of the directions of this court, Lordship, passed on 30/11/2016, Lordship, that has given some recommendations, Lordship, but Lordship, those recommendations were not considered, Lordship. Otherwise, an anomaly committee was also constituted, Lordship, and the report of the anomaly committee was placed, Lordship, that was considered. But the expert committee opinion was never considered, Lordship, in terms of the directions of this honorable court. So basically now, Lordship, that expert committee opinion, Lordship, it needs to be implemented. And that much only is my grievance, Lordship. If that is taken into consideration, Lordship, then the department can always review this, Lordship, by taking into consideration that expert committee opinion.
Finance Department stand is very clear that your pay scale has not been recommended. So that recommendation has to come.
Lordship, they are saying that anomaly committee has recommended one pay scale, Lordship, but instead of that, they have given a lower grade pay, Lordship. That, Lordship, was never directed by this honorable court, Lordship, on the earlier round of litigation. What was directed was to constitute an expert committee, and recommendation of that expert committee was to be taken into consideration, Lordship. The Lordship may kindly peruse page 31 once, Lordship. This is the order of this honorable court, Lordship. I would like to rely on paragraph 15 onwards, Lord.
Paragraph 15, my lord, at page 31 is very clear, my lord.
No, page 31 is a part of the order.
Yes, part of the order down below, lordship will see, my lord. My lord, in the middle portion, on the other hand, by relying upon the decisions of the Honorable Apex Court, that normally the applicability of the principle of equal pay for equal work must be left to be evaluated and determined by an expert body. Now here, my lord, the expert body, my lord, my lord, the pay commission. And also in view of the direction of the Apex Court in so and so, that state be directed to examine cases by appointing an expert committee. I am of the considered view that in the instant case also, ends of justice should be meted if a direction is issued to the state respondent to constitute an expert committee to examine the case and make a value judgment on the qualitative difference in the reliability and responsibility between graduate teachers in the high schools and the demonstrators in the higher secondary schools.
Now, the expert committee, my lord, did not make any such specific, my lord, recommendation. It was, my lord, put further to, my lord, verification by the anomaly committee. And thereafter, my lord, the finance department, after detailed examination, placed the matter before the honorable cabinet. With the honorable cabinet, my lord, the pay scale has been, my lord, determined. So this will, my lord, require full-length hearing, my lord. They have chosen not to file any affidavit in reply. It is for them, my lord. We have negated the claim of the petitioner.
It only talks about an expert committee.
Yes.
Now, by what name that expert committee is constituted?
Annex 5, page 39.
Hmm.
Lordship, the expert committee, Lordship will find at page 38, Lordship.
Hmm?
Expert committee was constituted, Lordship.
Yes, constituted.
Yes, and.
They have given a report.
And Lordship, page 39, there was a meeting held on 21/8/2017.
Yes.
In that meeting, Lordship, point number 2, that is relevant, Lordship. I am reading point number 1 also. The demonstrators are imparting education to the students of class 11 and 12, and they are assisting the postgraduate teachers mainly well as the assistant teachers of graduate skill imparting education up to class 10 only. However, the entry qualification of graduate teachers and demonstrators is almost equal. Number 2, the workload of graduate teacher is definitely high in comparison to the demonstrators, as they are to do various other duties in addition to teaching from class 6 to class 10. Therefore, all the members opine that the existing pay scale, that is emoluments of assistant teacher of high school, should be enhanced. Commissioner and Secretary, Chairman of the committee also agreed to the views of the members. The committee decided to apprise the above to the government of Assam. Subsequently, Lordship, this report was submitted and it's at page 60. Lordship has got
Page
page 40.
40, yes.
Report on the decision taken as per direction of Honorable High Court order
So
dated.
pursuant to this, there is another anomaly committee.
Lordship.
Pursuant to this committee, another anomaly committee was constituted.
Yes. Lordship, prior to this submission of this opinion, Lordship, that anomaly committee was constituted, and this expert committee submitted its report only on 2/11/2017, whereas Lordship, the anomaly committee submitted its report on 31/12/2017. That is, the anomaly committee submitted its report after this expert committee submitted its report, Lordship. But that was not taken into consideration, this prior one, Lordship. That expert committee which was directed to be constituted in terms of the directions of this court.
So you will have to demonstrate that what are the parameters under which your claims for
That was taken into consideration by this honorable court earlier also, Lordship. And
no, the earlier the court left it to the government to
Yes,
decide.
my lord. Court did not enter into the
Court did not go into
merits of
this
their
aspect.
claim. Yes, my lord.
went into the merits, Lordship, and said that the expert committee is the competent authority to decide whether
Determined by
there
an
needs to
expert
be validity
committee.
or not, Lordship. The expert committee subsequently has given its report, Lordship, and that was not taken into consideration. That is my grievance, Lordship.
Who were the members of the expert committee?
Lordship, at page 40, Lordship will find. I am reading page 40, Lordship.
Page 38.
The 40, Lordship, 40.
No, 38 is the expert committee.
Yes, Lordship. Uh, this was constitution of the anomaly committee, Lordship. The members of the expert committee, Lordship will find at page 40, Lordship. Lordship,
Yes.
Reading from the beginning, Lordship. As per Honorable High Court Order dated 30/11/2016 in WPC number 6470/2013, Raj Kumar Burman and 228 others. Just so and so, there are three writ petitions in all together, Lordship. The state government respondent authorities have been directed to constitute an expert committee to examine the case and make a value judgment on the qualitative difference in the reliability and responsibility between the graduate teachers of the high school and demonstrators of the higher secondary schools. The committee accordingly was constituted comprising of the following officials. Number one, Commissioner and Secretary, Secondary Education Department. Number two, Director, SCERT. Number three, an academician from Guwahati University. Number four, an academician from Dibrugarh University. Accordingly, the first meeting of the committee was held on 21/3/2017 at 11 a.m. at Commissioner and Secretary, Secondary Education Chamber. The committee was apprised of the matter and committee, as per advice of the chairman, agreed to include number one, Director, Secondary Education. Number two, Sri Satyan Das, Undersecretary, Secondary Education, as additional member of the committee. The second meeting of the expert committee was held on 24/7/2017 at 10:30 a.m. to arrive at a decision regarding pay parity between the graduate teachers of high schools and demonstrators of higher secondary schools in pursuance to Honorable High Court's order dated.
Prima facie, the direction of the court is to place it before an expert committee. An expert committee will advise.
Lordship,
Opinion of the expert committee is to be acted upon. Government has not acted upon.
no, that was never considered, Lordship, by the government.
So they
They
have
wanted it
they have
to-
constituted another committee.
Lordship,
But the decision for pay parity is with the government. You can certainly assail it on the ground of, you have to show us the parameters on which you want the court to invoke the writ jurisdiction.
that was taken into consideration on the earlier round of litigation, but
Which
Very-
paragraphs?
Lordship,
Which paragraphs?
Lordship, herein paragraph 12, 13, 14, 15, 16, 17, and 17 would be relevant, Lordship. A long judgment, Lordship. In fact, 11 also is relevant. May I read, Lordship? Paragraph 11.
Yeah, read.
In the instant case, it is the case of the petitioners that by qualification, both the graduate teachers in the high schools has Lordship got it. Page 28, paragraph 11, Lordship.
This will require examination of the process by which the expert committee recommended.
Lordship.
Your prayer is for a direction to the government to accept the expert committee.
Just to consider, Lordship. They have not even considered, Lordship.
We will consider that, was it placed before the authority? It was placed before the authorities.
My lord,
Lordship will turn to page.
It was
42
submitted
once,
on when? 2/11.
Lordship will turn to page
My lord,
42 once, Lordship. What was considered is there, Lordship.
No. How was the committee forwarded to the department? Was the committee forwarded to the department?
Lordship,
This committee is to be acted upon by whom? Committee report.
Lordship, by the government, Lordship,
That's right. Which department?
Education.
education.
So was it forwarded? What decision was taken?
Lordship, it's the Joint Secretary Elementary Education Department who forwarded it. Lordship.
Unless
Mr. Borpuzari?
My lord, we have filed the affidavit, thereby giving the entire history of the pay structure, my lord, relating to, my lord, graduate teachers and demonstrators.
No, that is okay,
My
but there was an expert committee constituted as per the directions of the court. Expert committee submitted some report. What happened to that report? Was it considered? Was it rejected? What happened?
So here, my lord, the expert committee report, my lord, my affidavit says, my lord, if my lord may be pleased to come to the repetition for a moment, my lord,
Yes.
what are the recommendations, my lord? The recommendations are not in black and white, my lord. It is not quantitative. They will have to quantify.
No, so that is what we want to know.
Absolutely.
Who has taken a decision? What
My lord.
was it considered at some level? Where have you stated it?
That, my lord.
It's not there, Lordship. I have challenged this, Lordship. Annexure 7, page 41, Lordship. That was,
No, page 38 of the repetition, lordship will kindly see, my lord, that committee was, my lord, constituted, my lord, by notification, my lord, issued by the secondary education department.
We understand everything.
Yes.
This has happened in pursuance to a court's order.
Yes,
Committee constituted.
yes,
Members were identified. They held a meeting. They gave a generic recommendation.
generic recommendation,
Right.
absolutely.
Now, somebody at some level will have to say that this is a generic recommendation,
Yes.
not quantified. We need the matter to be re-examined. Who said that and in what capacity?
Now, my lord, now going by my affidavit, my lord, perhaps, my lord, these recommendations were not placed before the, my lord, finance department. So finance department had acted on the regular pay commission recommendations. And the regular pay commission recommendations are clear. Regular pay commission, my lord, 2017, then my lord put to anomaly, then anomaly committees, my lord, that is of course.
No, why did the finance department act on that? On whose representation, whose directions?
My lord, it is periodical, my lord, because the pay commission is constituted periodically.
No, pay commission is okay.
My lord.
But
Now, yes, lordship is correct, my lord. This, my lord,
all the litigation has happened after the pay commission recommendation. That is why that is why they had come before the court.
Yes.
That in the pay commission, their cases were not considered, according to them. The court said, okay, hold an expert committee. The expert committee recommended. According to you, it was not quantified.
it was not quantified.
But-
And, yes, and
But
my lord.
whether
yes,
this decision was taken by the department or not,
Lord, therefore, my lord, if
Mm.
my lord is taking up that, my lord, expert committee recommendation, my lord, that page, my lord, page 38 onwards, so people kindly see in the writ petition, my lord, page 38 onwards. Page 38 is the constitution of the expert committee. There, my lord, will find, my lord, serial number 1 to 5. None of the officers, my lord, of the finance department was, my lord.
that
made
was
a-
not even a direction.
Yes.
You see that you have not assailed the order.
Yes.
You come to the order of the court. Come to page number 32,
Yes, my lord.
paragraph 16. You will find the officers who were identified. Finance is not there. Finance is not there. And this committee was constituted in terms of the direction of the court.
Here, perhaps, my lord, for that view of the matter, my lord, an affidavit from the education department will be required because it is they who have constituted the committee.
No, it is for you to decide. You are the finance. You
No.
tell us what difficulties are there. You bring it out.
No, my lord, we have.
In your
filed an
affidavit, you have merely relied on the anomaly committee.
Anomaly committee as well as the.
Now, why
recommendation
was
of
an
the-
anomaly committee necessary?
Anomaly committee was necessary, my lord, to, my lord, resolve anomalies, if any, my lord, made by the, my lord, or in terms of the recommendations, my lord, given by the pay commission.
So is it suo motu or somebody at somebody's uh, references?
It is, my lord, suo motu.
How can there be suo motu?
No, my lord, anomaly committee, my lord, anomaly, my lord, finance commission, my lord, makes, my lord, the recommendations. The pay commission makes recommendations. Now the recommendations are to be acted upon. Thereafter, my lord, a anomaly committee is constituted, my lord, with a further view, my lord, to examine the recommendations of the pay commission. Now
On
that.
the basis of some representations
Yeah.
made by some department to say, or some employees to say that.
Yes. It is for, my lord, anybody can, my lord, make
That's right.
recommendations to the anomaly committee.
Hmm.
But, my lord, the fact remains that, my lord, if no representations are also, my lord, preferred before the anomaly committee, then also, my lord, the anomaly committee is constituted, my lord, to examine the entire, my lord, recommendations of the pay commission. And therefore, my lord, lordship will kindly see, my lord, in the affidavit filed by the finance department, my lord, what the pay commission has, my lord, recommended, because the pay commission is the basic expert committee, my lord. It is periodical. Lordship will kindly take up the affidavit, my lord,
Hmm.
my lord, filed by the finance department. There, my lord, will kindly come to page number 20.
So his limited prayer is the expert committee having been constituted by under orders of the court
My lord,
and they having given a favorable report.
my lord.
Why was it not placed or considered before the authority? That's his limited prayer.
In fact, Lordship, the anomaly committee also recommended a higher rate pay in favor of us, Lordship, but that was even rejected, Lordship.
So that was rejected, my lord. The finance department, my lord, examined the matter and found that, my lord, the pay cannot be equated. So, and they have,
Lordship.
no, we have filed the
Basing on
affidavit.
the fact that
Therefore,
there were
my lord,
financial constraints,
why,
they did not provide us.
why
the
they are not
Why is that
entitled?
committee constituted then?
Yes, my lord, he is only speaking that committee. Why they are not, my lord, entitled? That we have
Any
spelled out.
affidavit from the education department?
No, my lord, we have not filed it.
Right. Matter be listed for admission hearing, 27th.
And, my lord, the expert committee, my lord, which has been, attention of which has been drawn to, my lord's attention, we have replied in paragraph 9 of our affidavit. We have duly replied how that, my lord, committee recommendations cannot be implemented, my lord.
There is no ground, Lord. As to why it
You
cannot be-
argue on 27th, we'll hear you. 27th of February. Twenty-seventh at the request of, as agreed to by learned counsel of the party, to be listed on 27th of February for admission hearing.
Lordship may keep it as part, right?
We have not even heard, we have not even urged the matter and you want us to keep it parted. No. 27th. Yes.
Lordship, we have received a communication from the Deputy Secretary where the BDO has been requested to submit fresh proposal for the payment of area salary to the petitioner.
When was this communication addressed?
On 14th of February this year.
Mr.
U. Sharma appearing on behalf
U.
of
Sharma appearing on behalf of the
Mr.
PNRD
Vinod.
department has placed before this court a communication addressed to the concerned BDO, namely BDO of Loairpua Development
Lower
Block, Post Office Hatikira, Loairpua District, Karimganj, requesting calling for the proposal, calling for resubmission of the proposal with proper particulars. at the earliest. In respect of grant of arrear leave salary as paid for by the petitioner for the period 2005-2011 to 2806-2013. Stop. Learned counsel appearing for the respondent submits that since this communication was issued on 14 February, matter be deferred for another 2 weeks, enabling them to apprise the court on the status. Accordingly, matter be listed again on 11 March, on which date the PNRD will apprise the court on the status of the proposal called for from the office of the BDO so and so. Yes.
May plead your lordship. Lordship, matter relates to non-payment of retirement benefit of the petitioner, lordship. Petitioner was retired in the year 2012, 30/11/2012, lordship. Leave salary, gratuity and CPF are entitled by the petitioner, lordship. Last occasion, lordship, on 14/9/2024, about 2023, lordship, the board authority filed one affidavit, lordship. Kindly peruse that affidavit, lordship.
Yes.
That affidavit, lordship, page 50, lordship, running page 50.
50.
50, Annex 1.
Yes.
Lordship, details of deduction made and amount payable to Sri Amal Bora, ex-salesman, lordship. Page 50, lordship.
50.
50, lordship.
There is no 50 here. Which annexure you are referring to?
Annex 1, lordship.
In that annexure, my lord, leave encashment salary details are not there, my lord. My lord, we kindly take note of this. I place before your lordship.
Annexure 1 sanction order.
No, lordship, details of deduction made and amount payable to so and so. Affidavit filed on lordship 14/9/2023 by the respondent number 4.
Affidavit in opposition by respondent 3 and 4.
3 and 4, my lord.
Filed on 22nd February.
The other one, my lord, filed on 14/9/2022.
14/9.
14/9/2022. 23, my lord.
Why you filed 2 affidavits?
Well, that was pursuant to direction of the court, my lord, the second.
Yes. Annexure 1.
Yes, lordship. Details of deduction made and amount payable to so and so, lordship. And this first one is in respect of gratuity amount, lordship. Lordship, they have calculated gratuity and thereafter they have deducted some amount, lordship, from me. And after deduction, lordship, around 4,27,752, lordship. That is now payable to me, lordship. That was deducted. Then, lordship, regarding CPF, lordship, same, lordship, they have deducted my amount and now that is round up 2,32,676, lordship. And regarding leave salary, lordship, that is not mentioned there. I am entitled leave salary 2,77,780.
I have placed before lordship, my lord, one order.
So total I am entitled, lordship, now 9,38,208, lordship.
Yes.
And then, lordship, they have calculated some amount, lordship. They want to refund from me, lordship. At the head of, lordship, house rent, lordship, kindly see that is serial number 4, 5 and 6. Lordship, serial number 4, house rent allowance already paid, which need to be deducted from him as he lived in a board house for the period effect from so and so 89,000 something, lordship. How they have calculated, lordship, that is not mentioned, lordship. My house rent was only rupees 10, lordship. That is not a quarter, lordship, only 2 room, 23 feet by 16 feet room, lordship. Total area, lordship. I am residing that room, 2 rooms, lordship. And thereafter they have calculated
What's
area.
the difference between page 50 and this?
Well, only the leave salary amount is not mentioned in page 50, my lord.
Why?
That was provided subsequently, my lord. The annexure page 50, that was provided, my lord, or issued, my lord, 8,
You bring
9.
it on record. You bring it on record. Why don't you bring it on record? Because this is also signed by the CEO, this is also signed by the CEO.
This is subsequent, subsequent, my lord.
Maybe
Yes, yes.
the earlier one says total amount 6,60,000.
Yes.
Subsequent one says it is
9 lakh.
9,38,000. Less the amount to be deducted.
Now, my lord, net payable amount as per the calculation of the board is 5 lakhs.
So she is disputing this amount which you are trying to deduct.
Yes, now, if may I please with the question. The writ petition was filed, my lord, claiming this CPF provident fund and gratuity amount. Thereafter, my lord, due to some misappropriations, some amount were deducted from her without holding departmental proceeding. So that amount cannot be deducted, that amount has to be paid. So this and that I have placed before your lordship, my lord, that says, my lord, the amount which have been deducted, already deducted, that is will be paid to her. Now, as she, the petitioner, my lord, he retired, my lord, on 2012, but he did not leave the quarter. And till date, my lord, the petitioner is occupying the
What are
quarter.
your rates? What are your house rent
Yes, my lord.
rates?
But initially, she was petitioner was allowed at rupees 10, my lord. Now, if my lord will take the affidavit in reply filed by the petitioner, my lord, on 15/3/2021. 15/3/2021, page 11.
Yes.
Page 11, amount of lordship, page 11. There, my lord will find that it was fixed at rupees 10 initially in the year 2000.
You are reading from which page?
Page 11, your lordship,
Annexure D.
Annexure D.
Page 11. Yes.
The first one will also will find you have to pay rupees 10 only as monthly rent for the aforesaid house. She was allotted, the petitioner was allotted, my lord, the house, and rent was fixed at rupees 10. Thereafter, if my lord now comes to page 14.
Instead of that, why don't you show us on what is basis you have arrived at this amount?
This is what I'm pointing, my lord. Here,
No, this is what you're pointing out for the court to calculate and arrive at this.
No,
Why can't you bring it from your office? That
it
this
is
is the amount.
calculated, my lord. It is calculated 2000.
Hmm.
The serial number 5, lordship will find the 91 months at the rate of 2000 per month. This 2000 comes from this letter, my lord.
This is in respect of second one, lordship, regarding serial number 4, lordship, how they have calculated
Yes, that I
89,000.
will come to it. That I will come, my lord. First, I'm dealing with 5 and 6.
Okay.
5, the amount 2000 comes from here.
Yeah.
Now, my lord, as per the Supreme Court direction, as the petitioner have not left the quarter, my lord, the panel rent will be the consequence, my lord. So, my lord, at serial number 6, taking into amount, the panel amount to be rupees 3000.
On what basis are you taking it? Do you have a schedule?
So, I'm sorry.
Do you have any schedule to show that what is the rent? Who has taken a decision to fix rent at from rupees 10 to 2000, panel at 3000? Who has taken the decision?
Then, my lord,
The board.
Page 14, my lord.
Is it the board?
Page 14, it is the letter is been issued under the hands of the CEO of the board.
So get us the resolution of the board. Rules and regulation. Where are your rules and regulation?
Regarding the
This is what the letter says at page 14. That you have violated rules and regulation.
well, the petitioner did not leave the quarter after retirement. The petitioner retired in the year 2012.
But Lordship, there
This
is,
order came up in 2020
No, but
pursuant to various
under
other.
what provision do you have this imposition of penalty for not vacating a quarter?
so far my knowledge goes, there is no rule, Lordship, regarding quarter. In fact, Lordship, kindly see page 7, Lordship, Annexure B of the same reply, Lordship. This is not a quarter, Lordship, only I was allowed to reside there, a small room, Lordship. That is in the year 1984, Lordship. Page 7. You are hereby requested to arrange the old room of the center which was used for keeping machinery and the vacant room of
This
so
order of
for
the Supreme Court
residential
may-
purpose of the present.
We are asking you something, you are giving us something else. We are asking you what is your schedule, on what basis you are coming to a finding that this will be 2,000, 3,000. Who has taken a decision? The chairman.
My lord, he is looking for some resolution today.
Where is that resolution?
That is not with me.
After two affidavits, you don't have a resolution. You don't have the rules to show us that these are the rules. Why are you not coming clean? Why are you giving us papers one after the other?
No, with regard to the panel rent, my lord.
We are asking you, what is your parameters for fixing rent, giving quarters? What does the rule say? How, when, to what is the period for which the quarters can be allotted? What is the rule regarding imposition of penalty? There has to be some basis.
I will look into it. I'll have to clarify, my lord.
What is this order that you're trying to show us?
My lord, if I may read from the second paragraph,
Hmm.
we however set aside the observation made in paragraph so and so and the principles of panel rent being charged, as we are of the view that if an employee occupies a quarter beyond a specified period, the panel rent would be the natural consequence, and such panel rent can be adjusted against the dues payable, including gratuity.
Correct, provided you have a resolution or a rule to say that this will be the period beyond which will impose penalty. Do you have that? In your affidavit, have you stated, have you given a reference? Then you have given a schedule showing the amount payable, which is enclosed to your affidavit. Today you file before this court another amended schedule where you have added another component.
But that is, she is liable to receive my.
Correct. So why is it not a part of the pleadings? What is the purpose of filing pleadings if at the time of hearing you are giving us documents one after the other? The purpose of pleadings
I
is
can
to
understand,
reflect
my
your
lord.
stand.
What had happened, my lord, on the second affidavit was filed pursuant to order of this court, and by the time, my lord, this order was not available, my lord, because it was passed subsequently. The earlier order was on 14/9/2022, and this one was that I have placed before lordship was issued later on 29/2023. This is a subsequent development, my lord. If my lord wants it to be on record, I'll bring it in on record.
It is not a question of me wanting it. There is a set of rules called the High Court rules. The rules indicate how pleadings are to be filed. As a counsel, I expect you to be aware of that. It's not about me wanting it. This is how the pleadings are to be filed. That is why the rules are published.
We had to file in a hurry, my lord, on that day, my lord, because of the order of the court, my lord.
It is your duty as a counsel to bring it on
No,
record.
that is-
It's not
that is
about
why,
the
my
court
lord,
wanting it.
It is not that by subsequent order, my lord, something we are deducting from her. We are giving it to her.
You are giving it to her, deducting an amount which according to you includes a penal amount. You are unable to tell the court on what basis you are imposing the penalty.
Penal amount is included in the affidavit, my lord.
Huh?
Penal, these 2,000 and 3,000 are there in the affidavit.
So what does your affidavit say regarding the penal amount?
Now, for that, my lord, we will require to go back to the affidavit file on 22/2.
Para 5.
No, my lord. 7. But the amount are not specified because that is
Then you will have to justify that this is the amount specified under the rules. Therefore, we are deducting it.
yes. But that 2000 was in terms of the letter that I have placed before your lordship, my lord, in the affidavit in reply of the petitioner at page 14. The 2000 from where the 2000 amount comes from. It was fixed at 2000.
No, no, 2000 fixed by whom?
I can understand what lordship is
You can understand, but you are not placing it before the court.
from. My lord is the query from my lord is from where the 2000 amount has come.
We want to know where are your rules, where are the parameters. Have the board taken a decision as to allot? Who decides? Supposing, according to the petitioner, this is an old house, old place, old shed, housing some machinery. He was allowed to stay there. Is this to be treated as a quarter? Is it a set of rules or is there any order permitting you to stay, madam?
Yes, my lord, page 12.
Was there any order initially?
Page 11
11.
of that affidavit.
Before that, lordship, annexer A, lordship, and annexer B, page 7. 1984, I was allowed. Since 1984. Page 7.
Page 7.
Yes. Then lordship, page 9 also.
Then the final order, my lord, at page 11.
Page
11.
Hmm. Does it reflect anything about penalty?
No, lordship. In fact, lordship, page 11, lordship, I see, you have to pay rupees 10,000 only as a monthly rent for the aforesaid house. You are not entitled to any house rent from the board. But lordship, annexer 1, page 50, lordship, they have deducted, lordship, now going to deduct, lordship, house rent allowance already paid. What house rent they have paid, lordship, that is not mentioned.
It is paper.
Yes. Yes, yes, yes.
Records, produce the records, my lord, or
Heard MS P. Bhattacharya, learned counsel for the petitioner, Mr. P. Munir,
One.
learned standing counsel, housing board. What is it?
Khadian village in this.
Khadian Village Industries Board. Although counter affidavits have been filed by the respondent board, the information regarding any rules or decision taken by the board, rules approved by the board or decisions taken by the board in respect of house rent and penalty in respect of accommodation to be provided to employees like the petitioner are not before this court. So Mr. Munir submits that he would like to produce, call for the relevant records and place it before the court for perusal if the occasion so arises. He therefore prays for some time. MS Bhattacharya, learned counsel, submits that earlier the claim shown by the payable by the petitioner was shown as rupees 6,60,428. And now, subsequent communication dated 2009-2023 issued by the Chief Executive Officer of the board reflects that the total amount payable to the petitioner is 9,38,208. However, they have wrongfully deducted, they are wrongfully seeking to deduct an amount of rupees 3,70,668 and showing only an amount of 5,67,540 as the amount which is ultimately required to be paid to the petitioner. MS Bhattacharjee disputes this deduction, saying that this deduction on the account of house rent and penalty is not supported by any rules or decision. In that context, let the reports be produced is after 3 weeks. 3 weeks.
Fix a date, Lordship, since 2002.
Upon record affidavit review.
19.
19 March.
March.
Or you have it on 12th of March. Yes.
Lovely.
12th of March.
With the records, well.
With the records, yes.
Lordship, we have an instruction which says that the petitioner actually expired on 2019.
Petitioner also expired. Petitioner also
Yes,
expired.
petitioner expired, Lord.
Or the petitioner's son expired.
Petitioner expired, Lordship.
What
Mr.
basis are you submitting?
Bina Borua, she expired, Lordship. There's an instruction from
None appears for the petitioner in call. It is submitted by Mr. Bodhakur, learned counsel appearing for the APDCL. Who has submitted a communication dated 27/11/2019 and submits that the petitioner, who is the mother of late Arup Borua, had expired on 7/10/2019. Stop. This information was furnished to the APTCL authority by MS Moushumi Borua, widow of late Arup Borua and daughter-in-law of the present petitioner. Accordingly, matter stands deferred for 4 weeks. Although none represents the petitioner, the petitioners are permitted to take steps for incorporation of the legal aids, if so advised in the meantime. Let's start for 4 weeks. A copy of the communication is retained in the case record.
Lordship matter may be fixed on Friday, Lordship.
No, Friday.
Friday.
Why Friday?
I'm praying on behalf of KDV, Lordship.
Huh?
I'm praying on behalf of KDV.
Friday.
Friday, Lordship.
All right, Friday. Mr. N.J. Khatoniar, MS Parasar, and
Behalf of Aram.
all right. Appears for the respective respondents. Yes.
Lordship, in this matter, we have been included one of the respondent, Lordship, but as no GA is shown, Lordship, so we missed this.
MSM Bhattacharjee, learned additional, yes. Senior government advocate submits that matter be taken up on another date. As she needs some time to complete the instructions. For which department? Labor.
Labor Department, Lordship.
It's the end of
Subsequently, this is made
And the
final.
counsel for the petitioner does not object to the case after 2 weeks,
Can a date be fixed, madam?
2 weeks,
15th of March, madam?
Yes, Lordship can be
15th of March.
Right. Deeply well.
deeply obliged.
Yes.
May I please your lordship, this case is regarding non-payment of family pension. The case is that
Pleadings are complete. Affidavit filed.
Hello?
Has any affidavit been filed? No. What do you say, respondents?
So basically, the appropriate parties proceed the PWD lordship of Pokrasar lordship. So
PWD, what do you say? But is it not covered by the writ appeal judgment?
Yes, it is. It's already covered matter. Lord.
It's already covered by the writ appeal judgment. Writ appeal 1.
Okay, what was judgment?
that is not covered.
Huh?
Instruction.
You are working as what? Work charge.
Works as employee, works as in a sanction post. In a sanction post. About 30 years. In this regard, I have referred one, I rely on.
No, there is a judgment of a division bench of this court.
Yes.
So that has rejected the prayer in respect of claim of pension.
That case is a different.
Why?
Because in that case, the petitioner were not employed in sanction post. In my case, I am engaged in a sanction post. In that case, it was because a person who is not regular government servant serving against a sanction post is not entitled to pension. But my husband was engaged in a sanction post. So that case is not relevant to her. No, I guess.
Where is the appointment order of your husband?
Appointment order page 21.
21.
Page 21. In the interest of public service and as approved by BSC at letter number BSC so and so, and subject to the approval by government, the Bidang Bosomotari, son of late Kantala Bosomotari of village so and so, Assam is hereby appointed as WCSA in the post of Sri Amdadur Rahman, WCSA, who has already transferred from this division under the establishment of the undersigned in the scale of pay of so and so. Against a sanction post I was in. And accordingly, the service book also maintained.
Where is your service book?
Service book is page 23, Miller. A type copy is page 32. Page 32.
Sanction cost pending নহয় ক'ব লাগিব নহয়।
Yes, rules for the PWD.
Of the service rule, it is clear that I was paid as per ROP rule. My, after 12 years, my grade pay was also enhanced. That is at page 39.
Yeah, Mr. Borpuzari, they are governed by page 43.
Page 43. No, my lord,
These two conditions are necessary.
conditions are necessary. Before that, my lord, paragraph 23 of my lord Upenda's decision.
Hmm.
My lord, for these reasons, we are of the view that in the fact situation of the case, master role workers, work charge workers, and casual workers are not entitled for regularization of their service with consequential benefits such as pension, etc. So, my lord, this direction, my lord, consists of, my lord, two components. First, my lord, one has to be, my lord, regularized. And only after regularization, my lord, that pension, my lord, can be.
No, but
my lord,
then,
reduced. Now, here is a case, my lord. Lordship has seen page 21. Page 21 of the writ petition, my lord. This is the initial, my lord, appointment engagement letter.
some review was filed against that.
Yes, that review is pending.
The review is
Yes,
pending.
a review, my lord, has been filed, my lord, the workers employees,
Because this page 43
my lord.
reflects that these are the two preconditions which are necessary for grant of pension.
Yes. Now, whether, my lord, here one aspect of the matter will assume vital significance, that is whether, my lord, the person was initially engaged in a sanctioned vacant post.
Yes, he was apparently from the appointment order.
So, appointment order, lordship will kindly see, my lord, page 21. In the interest of public service and approved by BSC Vider, subject to approval so and so, Bidang Bosumata is hereby appointed at work search section assistant in post of so and so who has already been transferred plus so and so other allowances. The appointment is temporary. It doesn't say, my lord, whether the post is, my lord, sanctioned. It does not say whether the post is sanctioned post. So therefore, my lord,
Sanctioned or not, because it is presumed to be sanctioned unless you give information that it was never sanctioned.
yes, therefore, my lord, the PWD will have to produce that instruction.
But
my lord.
assuming it is sanctioned, then are they governed by this?
If it
The
is a,
service book, it is
if it
clear.
is,
It is a
if it is a sanction post, my lord, then, my lord, if it is sanction post, then, my lord, his services has to be regularized before grant of any pension. That is precisely what page 43 kindly see, my lord. Page 43 of the writ petition, office memorandum dated 89.
Page 43.
Page 43. After careful consideration of all aspects, the Governor of Assam is pleased to order that after regularization of service of works or services beyond initial period of 3 years, works or services shall qualify for the purpose of pension TCRG, subject to fulfillment of the following conditions. Such work search period must be whole-time services. Such work search period must be continuous, and incumbent was not employed for a specific broken period. Now, these aspects of the matter, my lord, the employer, my lord, here the administrative department is PWD.
But then if there is a division bench judgment
Yes,
to the contrary,
to the contrary,
even if he satisfies according to you, it is not permissible.
it is not permissible because my lord, regularization is the condition precedent for releasing my lord pension. And pension, my lord, he is
Mr.
seeking-
Das, there is a division bench judgment, Upen Das.
Yes, my lord, that is not for the section against, for the worker engaged in section post. That is only for mere temporary employment. That judgment is regarding the temporary.
But you were never regularized.
But I was engaged in a sanction post, my lord. And this order and as well the service book also very categorically proved that I was in a sanction post.
Yes, PWD, you come up with your instructions.
this-
Your
what
your
is
factual
special-
instructions are necessary here. On which post he was appointed, whether it was sanctioned, whether he was regularized. Obviously, he was not regularized because his prayer is for regularization
Unless
in supernumerary.
unless it is a sanction post, why should I pay ROP pay scale as per ROP rule? Why should I my grade pay enhanced for 12 years? Unless it is a sanction post, the government would not have done that.
But you were not regularized.
A regular order is not there. But I am and I am also rely on one Supreme Court judgment, that is page 73 of the penalty. Relevant portion of the Supreme Court judgment. Where 35.
Yes, Habib Khan.
There are some of the employees who have not been regularized in spite of having rendered the services for 30, 40 or more years, whereas they have been superannuated.
No, you have to tell us that it is not covered by the. You have to show us that it is not covered by Upen Das judgment also.
Like, Upendas, it is not covered.
So you'll have to.
Upendas is a mere.
No, mere submission will not do. You have to take us through the judgment properly.
Yes,
But
lots of
before that,
penalties.
let us have the factual
No,
information.
I'm
No, Mr. Das, let the PWD file their affidavit or get their instructions. PWD, we are giving you an opportunity to complete your instructions. If not, we will have to proceed with the matter with whatever materials are available. Heard Mr. S. Das, Learned Counsel to Petitioner, and Ms. M. Das, Learned Standing Counsel, PWD. Mr. Arbor Pujari for Finance. And Accountant General, MS Porasor for the Accountant General. This writ petition is filed by the petitioner's widow. It's filed by the widow.
Widow.
Praying for grant of pension for the services rendered by the petitioner as a work charged employee under the PWD Kokrajhar Building Division. Till his death. While he died while rendering service.
Yes.
Till his death while he was in service. Stop. Learned Counsel for the petitioner submits that petitioner was appointed against a sanction post, and pursuant thereto his service book was opened. All benefits of increment, etc. were released to the petitioner. Therefore, for all practical purposes, although there is no specific order regularizing his services, petitioner rendered continuous services of how many years?
20 years.
20 years from the date of his initial appointment. Stop. Under such circumstances, his prayer for the prayer for release of pension to the widow of the late petitioner, late so-and-so, having not been considered by the authorities, the petitioner is before this court. Learned Counsel for the petitioner also relies upon the judgment of the apex court rendered in Habib Khan, as well as other judgments rendered by coordinate benches of this court. Mr. Das further submits that the orders passed by division bench of this court in writ appeal 1 of 2022, which was earlier relied upon by the respondent counsel, is not applicable in the facts of the case, as the petitioner in the writ appeal, as the persons concerned in writ appeal 1 of 2022 were never appointed against a sanction post, while the present petitioner was appointed as a sanction post and rendered his service from his date of initial appointment. So, Mr. Das further disputes the contention of the respondent counsel appearing for the finance department, Mr. R. Borpuzari, that the petitioner's claim is not admissible in view of a decision rendered by another division bench of this court in Upendas versus State of Assam and others. Stop. Mr. Das submits that in Upendas also, the judgment was rendered in respect of persons who were never employed against sanction posts. In that view of the matter, the respondent PWD department will complete their instructions and place before the court the factual aspects involved in the matter regarding the process of appointment of the petitioner, whether the post he was working is a sanction post, and such other particulars as may be necessary to address these issues raised in the writ petition. The respondents are at liberty to file their affidavit if so advised. Let the matter be listed in the month of March, third week of March.
Yes, definitely.
And a copy may be served, extra copy may be served.
22nd March, and extra copies, if required, be furnished to the respective standing councils within the course of this week. List accordingly. Yes.
My please, Your Lordship. My lord, as per the earlier order, my lord, the department is required to file affidavit, my lord, on the basis of the instruction.
I have received a recent instruction, my lord, regarding filing of representation by the writ petitioner, my lord. The review order, my lord, there is a direction to file a representation by the individual petitioner. So that representation is it to be filed, my lord.
Where is the review order?
Review order, in fact, my lord, in the proceeding, review order is not there, but in the subsequent letter, in the instruction, my lord, the direction is there, my lord.
What review order?
In the review order, my lord, direction was given to.
No, what review? Review against what?
Department has filed a review, my lord, against the order of order dated, my lord. It was 9/8/2020.
No, this is.
There was a direction to regularize their service, my lord, who have appointed against vacant post, my lord. So we have filed a review, my lord, that there was no sanction post. So in that review, my lord, there is a direction to file individual representation by the petitioners and to consider on the basis of the available record. And if they are appointed against sanction vacant post, my lord, then regulation is to be considered in accordance with law. So pursuant thereto, my lord, we have called for the records from the director office and we have considered the individual representation filed by the other petitioners. But in respect of the present petitioner,
he was a petitioner in the earlier round.
Yes, my lord.
therefore also added in the review petition.
Yes, my lord.
What do you say?
My lord, regarding the review petition, my lord, though, my lord, I was arrested as a party, but no notice or no information was laid to me, my lord. So petitioner is unaware, my lord, regarding the review.
You go and check the order.
My lord, I have checked, my lord, but from the, my lord, the communication, my lord, served to me, my learned friend, my lord, the, my lord, hearing was fixed on, my lord, 23 to 2024. So, my lord, I may be allowed to be present before the hearing authority, my lord.
You file
with-
your representation
my lord,
first.
I may be allowed to.
Let him file.
Yes, my lord. Yes, my lord. We'll consider, my lord. Once he's filed, my lord, we'll consider it, my lord. We'll give personal hearing if required, my lord.
It is submitted at the bar that pursuant to the orders passed in the orders dated 9/8/2022 passed in review petition 52 of 2022, which was preferred by the state of Assam against the order passed by coordinate bench. The review petition was disposed of with the following directions, para 18 and 19. So, Learned Counsel for the Education Department submits that notwithstanding the directions, this particular petitioner has never approached the authority by filing an application, individual application. Stop. It is submitted that the petitioner was also arrayed as a party respondent in the review petition. Where Mr. Islam submits that although he was arrayed, he was not aware of the order passed. However, he craves liberty of the court to now approach the authority and file necessary representation. Stop. Such prayer is not objected to by the respective, by the department counsel. Stop. Under such circumstances, we permit the writ petitioner to file an individual representation as directed by this court by order dated 9/8/2022, passed in review petition 52 of 2022. And upon such an application being filed with the petitioner, the authority will expeditiously will look into the claims and expeditiously address the issues raised and pass a speaking order. Stop. Let the exercise be completed after receipt of individual application within a period of 30 days.
Yes, my lord.
From the date of filing of such an application. Stop. In terms of the above, writ petition stands closed.
My lord, may be kept pending, my lord.
Why?
My lord, if my lord, it is,
It give you liberty. You come back with liberty. How can you approach two different authorities on the same issue?
because my lord, already some findings of the honorable court passed in this case by order dated, my lord, 20.
You are agreeable to filing a representation before the authority,
My lord.
and you also want to keep the writ petition pending. And assuming there is an order against you,
My lord.
you may be required to approach the court
My lord,
again.
I will bring out record, my lord, by filing it affidavit, my lord.
What?
If my lord against me, any order passed against me, my lord.
No. This is not how proceedings should be allowed to proceed. Writ petition accordingly stands closed. Needless to say, if any grievances remain unaddressed, the petitioner is at liberty to approach this court. Disposed. Interim
Obliged.
orders, if any, stands vacated.
Obliged, Lordship.
Yes.
Highly obliged, your lordship.
Maybe.
Yes.
Lordship, our affidavits have been sent for vetting, Lordship. We seek 2 weeks time to file it. Lord.
What are the grievances here?
My lord, grievances, my lord, the petitioners have served in the Department of PhD, my lord, for more than 30 years. And they have got their regular scale of pay, revised scale of pay, as well as the EB crossing, everything like other employees, my lord. And after their retirement, my lord, they have been given the only provisional pension, not the final pension. That is the
Why?
given.
Why?
That is, my lord, that
there was a proposal before the AG Assam, and AG Assam returned it back, asking that whether the service of those persons have been regularized or not, my lord. In fact, my lord, the Assam government office memorandum is there, which prescribes that, my lord, if an employee completes the service of 20 years, he is entitled to, my lord, pension. That fact is there, my lord. I've given the office memorandum.
Office memorandum.
Yes, Lordship.
Dated?
Dated 12/9/1996. I think it's there in the file, my lord. In the government of Assam circular issued under office memorandum dated number such and such dated 10/8/63 of Finance APF Department, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefits as available to a retiring confirmed government employee either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. This OM came into force with effect from 1 September 1982. Thereafter, my lord, there is
affidavit come. There are factual issues.
Yes, sir.
Mr. Pothakur, learned counsel for PHE. Prays for further time to file an affidavit on behalf of the department. Mr. Purka, still learned counsel for the petitioner, does not object. It will be listed after 4 weeks.
My lord, I pray for a date, my lord, in this.
They'll file. You may like to file. What is the point in fixing a date?
But their filing has to be ensured, my lord. Otherwise, every time they are taking time, there's nothing, my lord.
My lordship, I'm appearing in item number 30, my lord.
Your name, please?
PK Day, my lord.
Mr. PK Day appears for the petitioner in item 30. Anyone else appears? Yes, please give your names in the sheet. Yes.
Lordship, here in this matter, Lordship, the government has placed the pension papers in original to the Director of Higher Education for onward transmission to the AG office, Lordship. So I need 2 weeks further time to obtain the updated instruction, Lordship. It was placed.
Lord. In fact, my lord, AG has submitted their affidavit way back, my lord. Only they are waiting for submitting the pension papers of the meeting.
When is it likely to be sent?
Lordship, let it come after 2 weeks, Lordship. It will be placed before the AG.
Mr. D. Upamanyu, learned standing counsel,
Higher Education,
submits that the pension papers of the petitioner have been received from?
Has been forwarded by the Joint Secretary, Government of Assam, Higher Education Department.
Have already been forwarded?
Yes, Lordship, to the Director of Higher Education for onward transmission to the AG office, Lord.
You are appearing on whose behalf now?
Lordship, on the Director for the Higher Education Department, Lordship. It is in process, Lordship. It will be placed before the AG office.
Submits that the steps required to be taken by the department for forwarding the proposal to the Office of the Accountant General is underway, and the state papers will be forwarded to the Office of the Accountant General within a period of 2 weeks from today. Mr. S. Chaudhary, learned counsel for the petitioner, does not object to the prayer made, does not oppose the submissions made. The court is of the view that the matter be deferred for 3 weeks, enabling the standing counsel to apprise the court as to the status of the pension papers to be required to be forwarded to the Office of the Accountant General's office. Stop. The Mr. R.K. Talukdar, appearing for the Accountant General in the meantime, on the next date fixed, will also apprise the court whether the pension papers have been received from the Office of the
Director of Higher Education.
Director of Higher Education. list after 3 weeks.
My lord, any fixed date is lordship may give.
15th of February,
15th, Lordship.
March.
March.
Oblige,
Yes,
Lord.
33.
Your lordship will kindly see two orders, my lord. One is dated 21/8/23 and 19/1/24. 21/8/23 and 19/1/24. She retired in January 22. She did not get any pension. Nothing is there, no retirement benefit is there. Instruction.
Instruction this becomes a matter with BTC matter.
Yes,
My lord, I am appearing on behalf of B. Chaudhary. My lord, we have received some instructions, my lord. May I produce before this honorable court?
what instructions? Tell us.
My lord, may I read, my lord?
Read.
The undersigned, the pension papers and original service books in respect of the petitioner forwarded to the Director of Education, BTC Kokrajhar, by this office letter number so-and-so dated so-and-so for her finalization of pension and DCRG and house pet complex.
Who has
This
issued that instruction?
My lord, Inspector of Schools, Sirang District.
Then what is when was it forwarded?
My lord, 17 January 2024.
Then what is the status now?
My lord, actually, Mr. B. Chaudhary appeared for this matter.
Let the officer hear my submission, my lord. The lordship, the video conferencing may be done because they are just, my lord, neglecting the whole thing. Two orders I have shown, my lord, 21 August 23.
We'll keep it on Friday.
Video conferencing with the officer.
We'll see about that. Please ask Mr. Chaudhary to apprise the court as to the status of the pension papers. You can't sit on the pension papers like this.
My lord.
How long does it take when the inspector has already forwarded? How long does it take for sending it to the appropriate authority?
On Friday, my lord. You will apprise the court, my lord.
Friday. Is Friday convenient for you, Mr. Das? Okay.
Otherwise, my lord, they will have to appear in person.
Yes, we'll.
So that otherwise they are not taking it seriously, it seems.
It is submitted by Mr. Das, B.D. Das, Learned Senior Counsel, assisted by MS Deka.
Yeah.
That the pension payable to the petitioner has not been released, and no information is forthcoming from the department. Stop. Your name, please. Mr. Chaudhary, you are here.
Yes, ma'am.
What has happened?
Lordship, the Director of Pension returned back the papers saying that there was an overdrawal.
No. Now we were informed that it has been sent back to the director.
No, Lordship, the school principal has been directed to submit the papers giving the proposed salary statement, pension statement, Lordship. That has not been done till date.
When was it directed?
Lordship, on 22nd December 2023.
Then how long does it take for the school principal to send this information? Your
Lordship, principal has been represented by another council, Lordship.
They are under you, Mr.
Yes,
Chaudhary.
Lordship, but we have sent the reminder also,
You
Lordship.
cannot wash your hands to say that we have issued letters and they are not acting on it. We'll record that. The
No,
BTC is
Lordship, it will be done. Lordship may take it up on Friday or Monday, Lordship.
On Friday, my lord, let it be on Friday. And more than 2 years, nothing has been paid to her. No gratuity, no other pensionary benefit.
Okay, we'll give him time till Monday. Monday? Let it be on Monday. We want your concrete instructions.
Yes,
No, they should pay the provisional pension.
At least there is a direction to release the provisional pension. What is the difficulty there?
Provisional pensions can be paid.
Matter be listed on Monday, that is 26th of February. by which date the Standing Council, Mr. B. Chaudhary, Standing Council BTC, Mr. B. Chaudhary will apprise the court as to the status of the finalization of the pension of the petitioner and also as regards the release of provisional pension as has been
And other pensionary benefit.
and other pensionary benefits has been directed by the court earlier. Mr. B.D. Das, Learned Senior Counsel, assisted by MS so appears for the petitioner, list on 26th. It's-
Lordship, here in this matter, Lordship, on the last date, Lordship, we requested the AG to furnish us the last pay slip of the petitioner, Lordship. It was received on 5th of February 2024, Lordship. So, Lordship, the provisional pension has been processed, Lordship. So, Lordship, let it come after 2 weeks, Lordship. I'll get the instruction, Lordship. We have received it on 5th of February, Lordship.
Yes.
But Lordship, we have reported one sorted.
Mr. D. Bhuya appears for the petitioner, Mr. D. Upamanyu for the health.
Yes, Lordship.
Submits that the pay slip sought for from the Accountant General's office has already been received on 5th of February.
Yes.
And the matter is now under consideration by the department for release of provisional pension.
Yes, Lordship.
He submits that the necessary orders may be issued by the authorities within a short period of time. Mr. R.K. Talukdar appears for the writ petition. Accountant General. List this matter again on 11th March.
Highly obliged.
Very pleasant. This is second round of litigation of the last petition. These state respondents are directed to file affidavit. But since they have not filed any affidavit.
Lordship, I prefer some time.
Already they just speaking on our Lordship. Our grievance is that Lordship, he was appointed as a casual employee. Till 2016, he was paid fixed salary of 900. And as per Upendra's Lordship, since the casual employees are entitled for the minimum pay scale. So that was my grievance. But that is not negated, saying that Lordship, I was appointed by the school managing committee. That is why not I am entitled. But I have annexed some of the documents where already in 2009, 10, 11, Lordship, they have submitted proposal and accordingly paid my fixed salary as a casual employee. And proposal was also Lordship submitted at that.
Where is the rejection order?
Our rejection also Lordship will find at page 20, annex at 20, page 77. Lordships, this seen in the third line, they already said honorary casual employee. Annex at 20, page 77. They have not, Lordship, going to the letter and spirit to the direction of the earlier order, Lordship. Lordship, before that, kindly come to page 75, Lordship. What was the direction and what was supposed to be considered? That was not done. Page 75. From paragraph 3 onward. May I read, Lordship?
Yes.
The petitioner claims that the petitioner was initially appointed on 13/10/1987 as a Chowkidar grade 4 employee by School Managing Committee of Mornoy Deuri Cup Basic School, Bahgarh, under Bihpuria Educational Block in Lakhimpur district. The petitioner had been receiving fixed pay salary at the rupees 900 per month from the date of appointment till September 2016. Although the government had enhanced the fixed pay salary of such employees in terms of the WAM issued by the Finance Department from time to time, as per WAM dated 20th September 2004, fixed pay was enhanced at the rate of rupees 1800 per month. Subsequently, another WAM enhanced the fixed pay salary of casual employee from 1800 to 2100 per month. However, the petitioner continues to get the fixed pay of rupees 900 in spite of enhancement of the fixed pay. Therefore, it has been submitted that subsequently the government issued another WAM dated 15 to 2006, by which the fixed pay has been revised from 2001 so and so. The learned counsel for the petitioner submits that subsequently there has been another revision of this fixed pay by enhancing to rupees 4,500 in terms of order dated in terms of the order passed by the court in writ appeal number 45, 2014, which was disposed of on 8/6/17 in the case of Upen Das and another so and so so and so. The counsel for the petitioner submits that the state government has already agreed to pay minimum pay scale attached to the post of grade 4 to those who are not regular employees but who were appointed prior to 1/4/1993, and accordingly stated that such employees have been given the said minimum pay scale of rupees so and so per month. So in view of the above, learned counsel statement submits that authorities will examine the claim of the petitioner and pass appropriate order for enhancement of the fixed pay if he is entitled to. Now, Lordship, kindly come to page 77 and Annex 20. Within time frame, within 2 months, they are supposed to consider the case, Lordship.
No, who has released your payment all along?
The authority, the director,
From which date?
from the date of appointment till 2016. Lordship, kindly come to the
No, date of appointment, you were appointed by the school managing committee.
Yes, as a casual employee, Lordship.
Then
They kindly come to page 48. This was the communication, or this was issued from the director, page 48. This is a relevant paper, Lordship, page 48, to the commissioner, Lordship, enhancement of fixed pay of casual employees. With reference to the so and so stated that the casual employees were engaged in the Gov senior basic, junior basic school, and also engaged in the district offices of the DIF schools and block offices, and accordingly their salary were paid at the rate of rupees 370 to 900 as fixed pay. In this connection, it may be stated here that it should be some.
you are appointed as a casual employee in what school?
In the morning, Lordship. Lordship, kindly come to then proposal submitted Annex 50. This was the proposal submitted by the DO to the.
Your name?
My name is Lordship serial number 1, Basudev Deuri. Appointment date 13/10/1983 for necessary of Chowkidar, the school. The reason is given. But this was, Lordship, submitted by the DO in compliance of letter of 49, page 49. This was issued by the director to the DO, some information against the engagement of casual employee. So accordingly, this was submitted. Page 50.
Yes.
But now they're trying to say their Lordship, I was appointed. Yes, I'm not denied. I'm appointed as a casual employee by the school managing committee of the Deamornoy Junior Basic School. I am not claiming for regularization, Lordship. My prayer is, Lordship, for the enhancement of minimum scale, Lordship. And this reason is for regularization. If somebody is claiming for regularization, then he has no any right for claiming regularization if his appointment is given by the school managing committee. And already they have their sanctioning letter also, page 38, page 39, and page 40. Lordship, may kindly see for page 38, Annex 6. This was issued by the Deputy Inspectors, North Lakhimpur, to the Director. Sanction for payment of casual employees. Inform you that casual employees as per list have been working in the defined government junior basic schools since 1983. Had been receiving payment.
Yes, Mr. Sharma, what do you say?
Lordship, here after open instruction, Lordship, otherwise that speaking order, Lordship, page 77 says.
Yes.
That order, same.
Seeing the inquiry report submitted by the director level inquiry committee constituted to examine the claim of the Basudev Deori, the petitioner on contempt number so and so arising out of the petition number so and so, wherein it is stated that the petitioner Sri Basudev Deori was appointed by the school managing committee as an honorary casual employee chowkidar at Monroe Deori Government School in the year 1987. It is also stated that the inquiry report that no formal appointment letter was issued to in the name of the petitioner from the appropriate competent authority, that is Director of Elementary Education, Assam. And the school managing committee is not the competent authority to appoint any type of post in government schools. Seen the so-called appointment letter of Basudev Deori, it was signed by the headmaster.
No, but
of-
is there a finding that after provincial, it got provincialized, isn't it?
Full provincial, Lordship.
Provincial act. So
Prior to
government-
your appointment?
Yes, Lordship.
Prior to your appointment?
Yes, Lordship.
Then how were you appointed by the school managing
No, here,
committee?
Lordship, I am not claiming for any Lordship.
Whatever
but
it may be, in a provincialized school, how can the school management committee appoint you?
because there is a necessity of the for appointment.
Maybe, but they're not reposed
already,
with the
Lordship,
power.
Till 2016, there it is not the case that I am not any entitled for salary. They have already paid. And the director also, Lordship, in 2020 submitted a report saying that he Lordship is receiving salary, Lordship. If you Lordship allow me to place that document, but this was also not discussed, Lordship, in while passing this order. Probably they're saying that I was appointed managing committee, but that I am not denied, Lordship. But this is in respect of only for regularization or for any regular appointment. Here it is a case, Lordship, I am not claiming for any regularization or Lordship appointment. Here, Lordship, I am claiming for the minimum pay scale in view of retail bill of 45 of 2014.
This order was passed pursuant to a direction of the court.
Yes. And this direction was also kindly see the paragraph 7, page 76. In view of above, page 76. This was not discussed anything, Lordship, while this issuing this order. Page 76, paragraph 7. In view of the above, the present writ petition is disposed of by directing the respondent authorities, more particularly the respondent numbers 1 and 2, to verify the claim of the petitioner, and if it is covered by the aforesaid order passed by this court, in writ appeal number 45, he may also be granted minimum pay scale of that court. But
What
regarding-
is the direction in that judgment?
But in writ appeal,
Uh,
in writ appeal, Lordship, this state respondents have Lordship saying that, Lordship, the
Para
casual.
22,
Yes,
para 22,
para 22.
page number 72.
Yes,
Then
it is however hard. May I read, Lordship? It
yes,
is however,
with regard to masteral work charge.
yes, or casual employee, Lordship.
Uh,
It is however heartening
and
to learn.
other similarly placed employees.
Yes, the similarly placed are casual employee, Lordship. But this,
That there is no direction. It is a submission of the respondents which was recorded. Now,
no, this state government has agreed.
they agreed, that was recorded.
Accordingly, Lordship, they have issued this order, Lordship. I have annexed that office memorandum, Lordship, in compliance with the time.
But merely because they've agreed, would it denude them of their powers to find out whether you are entitled or not? Your
But
status
that
as an
decision-
employee.
That decision is not taken. If you go by the words of the speaking order, so regarding the writ appeal and direction, also there is nothing discussed. Only saying that reports in.
They're saying that since
Nothing.
you are appointed by the school management authority,
Yeah.
the appointment letter of so-and-so is not valid. And claim
No,
of the
this is
petitioner
noted-
is thereby rejected.
Yes, but this is in respect of while somebody is claiming for regularization, Lordship, for appointment, but here it is a case is a temporary appointment. Temporary is appointment by the school authority, Lordship, and they have already submitted proposal
Who
as a
is,
casual employee.
you verify and tell us on the next date,
And before
what
that,
is the
Lordship,
status, who is paying the salary?
the
Who
same
is paying
director,
the salary?
Apparently, Lordship, the school managing committee, Lordship.
No, it is not clear from your order.
Lordship, I will file a detailed affidavit. Lordship,
Lordship, page 40, this is their proposal from
I
the
filed a
Deputy
detailed
Inspector of School, page
Whether you
40.
file a detailed affidavit or not, half detailed affidavit, we don't know, but we want a specific
Lordship.
query from the department, you'll have to give us these
Lordship,
answers.
Lordship, for a
Legal
mo-
affidavit doesn't help us unless this
Lord.
information is available. Yes,
For a moment, kindly see page 40. This is the Deputy Inspector of Schools. The name of the petitioner, CL number 3. This is the proposal for payment of salary. Serial number 3, Basudev Deori, Devamorna Junior School, 14,800. They have submitted a paid lordship. And they are asking for lordship proposal also.
this is a statement.
Now, this
accompanying-
statement is lordship statement showing the area salary of the casual employees working in the school, so and so and so. And this was submitted. There is a reference, page 39. Sanction for payment of casual employee. And they have not denied this. They have not been paid salary till 2016. Only says appointed that I have only in the first paragraph I have stated I was appointed by the managing committee. But where is the finding regarding the particular direction? Nothing.
Mr. Counsel, your initial entry itself is irregular.
That's true. Not that.
No, if it is true, then where is the further claim of getting area salary?
Lordship, that is only for if somebody is claiming for regularization or appointment, lordship.
You are trying to submit, you are trying to make out a case that notwithstanding that your initial entry is irregular, you'll have to be given the higher scale merely because you're not asking for regularization.
No, it is in the authority, lordship, the saying the lordship, I am entitled for this
Authorities have whatever they have done, but where is your right to make this claim? Where is your right?
Since I was appointed as a temporary.
You
or
may have
casual
been
employee,
appointed, but where is your right to claim for a
being
higher
casual
salary?
employee, I have the right.
Have you seen this order? Have you seen this order?
Speaking order, lordship.
Yes.
Lordship, being a casual employee, I am lordship claiming this.
No. See the last line.
This is issued in compliance.
So-called appointment letter of so-and-so is not valid. That's a finding. Your appointment has been held to be not valid. Appointment letter not valid means what?
But they have not lordship saying that I was not lordship paid salary till 2016.
They're not. Whatever you have, whatever salary you have been paid, you have been paid.
Since I have been paid as a casual employee, so that is why lordship I am here lordship as a casual employee I am claiming for investment.
That is what the query of the court is. Your demand is that you have to be given a minimum of pay scale as per other casual labor, provided your claim to the post itself is considered to be legal. In a provincialized school, where is the scope for the school management committee to appoint anybody?
There is lordship no scope.
Then?
But the fact remains lordship that being a casual employee, whether I am entitled for the minimum pay scale or not.
No. In the prima facie view of the court, you are not entitled because you are not at par with the other employees.
But that too, those things that they have not denied, lordship.
They may not have denied. It doesn't appeal to us. If you want, we can pass an order today itself.
No, regarding the page 47, already I have seen lordship, they already submitted proposal and paid. their
Whatever
salary,
you have
lordship.
received, we are not commenting on that. That you're not, it is not payable to you. It is up to the government to decide.
But to let them clarify, lordship,
But
whether.
what is there to be clarified? They have stated that your appointment letter is not valid.
But
Do you
regarding the
discount that?
payment of salary, they have not said anything, lordship.
Hmm?
Regarding my payment of my monthly salary, they have not said anything, lordship.
May not. Your claim that they must say doesn't appeal to us in view of the fact that you are not denying that.
But here lordship, grants of the petition for only for the minimum pay scale, lordship, or fixed pay salary.
You have to argue like a counsel, not like the petitioner. You must make out your case on the basis of the parameters set by law. You satisfy us that notwithstanding your appointment being not regular
So since my appointment is a temporary of nature, lordship,
by an authority who's not even vested with the power to make that appointment. Not only you are working
lordship.
under orders of an authority who's not empowered, you are getting a salary. Now you are asking for an enhancement of a salary. Tomorrow you'll ask for regularization. Then you'll ask for pension.
Already,
These are
lordship,
public funds.
already,
These are
lordship,
public
before
money.
the man retired from service, they have been paid. But till
We are
the
not
death-
commenting anything, but
Lordship.
to insist that you are entitled to be given a higher scale on the basis of this particular order, unless you bring some supporting materials, it doesn't appeal to the court, prima facie. Matter stands deferred at the request of Learned Standing Council to apprise the court to file their affidavit as prayed for. Mr. A. Decca appears for the writ petitioner. You show us any authority that notwithstanding, yes, you are entitled to the services rendered. You are entitled. We agree with that. But to make a claim that you are at par with other employees will require examination.
So if you go by the definition of casual employee, then if the nature of appointment is
Casual
temporary, or there is some
employee will have to
necessity,
be understood in terms of the order passed by an authority who is competent to pass that order.
let him have, I will let him have instruction.
List after 2 weeks.
So that may be 6 weeks. Otherwise, the man is also retired. Is the last hope of NS for minimum pay scale. After 2 weeks, any
After 3 weeks, Lordship.
We'll give you 6 weeks, but we want your affidavit. If your affidavit is not on record, we are passing consequential orders.
We'll file it.
List on 18th March, by which date the respondents are expected to file their affidavit as prayed for.
I believe Lordship, in this case, instruction is sought for. I'll place the order 23/6/2024.
Lordship, here, director has instructed the DO to send the record along with the proposal.
Why do you tell us these instructions? How are we concerned what the director has done, what the BDO has done? We want you are representing whom?
I'm the entire department.
Entire department. So how does it matter to us that intra-department there are communications and you are apprising the court that this communication has gone from this office, it has received in that office? We want your stand.
Lordship.
Do you have a stand in this writ petition
No,
in
once
which the petitioner has prayed for?
Once the record are sent to the office of the director by the DO, Lordship, the director will verify and.
Are you saying that the director is helpless to present the findings of the department before the court because the subordinate officer is not sending it?
No, Lordship.
Then what are you submitting?
Lordship will fix after 2 weeks, Lordship.
Not 2 weeks, 1 week.
Lordship.
Date may be fixed, Lordship.
We'll start imposing heavy cost and pass orders if you don't comply with your instructions.
Lordship.
These matters can be deferred at the request of the department because you are not posted with the required instructions.
Lordship.
Mr. P. N. Sharma, Learned Standing Council, submits further time is necessary to complete his instructions. Mr. Your name, please?
I am.
Hi, Ahmed, Learned Council appears for the petitioner. List after 2 weeks.
Date may be fixed, Lordship.
We can fix dates, but unfortunately, you have agreed to his request. We fixed it at your request. You are not willing to argue the matter. You have agreed to his request. So what is the point in fixing a date? So you wait until the affidavit is filed. After 2 weeks. If we fix a date, we intend to pass some specific order, not for giving a further date.
Obliged.
Please, Lordship. Kindly the matter may pass over for a timing, Lordship.
Time being at 2 p.m. Yes.
My lord, here I have received instruction. As per instruction, my lord, petitioner is not entitled for area survey because petitioner's service was provincialized in the 2016. And he is claiming for 2013 to 2016. It's annexure 29, my lord, the provincialization order.
My lord, let them file affidavit, my lord.
Instruction is there.
What is that instruction about?
Instruction is that petitioner service was provincialized in the year of 2016, and he's claiming for area survey from 2013 to 2016. At that period, another person was in service, my lord, and after cancellation, in place of him, he was appointed. Page 29, my lord, page 29.
29.
Yes.
What is the name of the petitioner?
Here, my lord,
Name of the petitioner?
Suraj Ali.
Suruz Ali.
May I submit, my lord?
Hmm.
What happened, my lord? The petitioner was appointed in the year 1994. And the school was
Where is the appointment order?
appointment order. I have not annexed, my lord. I have stated in page 4, para 2, my
Why
lord.
have you not annexed?
It is there in the record, my lord.
You don't have it. You don't have it.
Presently, my lord, in this case, I have not annexed.
Hmm.
My lord, if requires, my lord, I'll file additional affidavit.
No, if required, you have to tell us whether you require to bring it on record or not.
My lord.
We are only asking you where is your appointment order. Yes.
Then, my lord, the school was provincialized, my lord, in the year 2013.
No, who appointed you?
My lord, the managing committee, my lord.
Managing committee.
And I am the senior most teacher in the school, my lord. Later on, my lord, in place of my post, one Abu Talha Samsud Doha was provincialized, and there were several litigations in this court, my lord. And finally, while the director of elementary education, my lord, cancelled the provincialization order of the Samsud Doha, and my post was regularized, my lord, in the year 2016. Now, my lord, the school has been provincialized with effect from 1/1/2013. And other similarly situated teachers, they have got the provincialization effect with 1/1/2013. And accordingly, my lord, a proposal for area salary, my lord, with effect from 1/1/2013 to, my lord, 28th February 2018, my lord, was sent to the director, my lord. Now, my lord, they are saying I am not entitled, my lord. Whereas, my lord, my lord, the similarly situated person, they have, my lord, the department has granted, my lord, the area salary with effect from 1/1/2013 on a departmental order. In another case, my lord, I have collected, my lord. Now, this honorable court, in different, my lord, cases, my lord, it is held
So
that
you were initially not provincialized.
Yes, ma'am.
Somebody else was.
Yes.
Because of orders of the court, it was cancelled.
my lord,
In that place, your name was provincialized.
my lord.
Now what
But
is it?
I should have been provincialized with effect from 1/1/2013 due to mistake of the, my lord, the authority, and due to oversight, my
Have
lord.
you approached the authority? Did you approach this court challenging that?
Yes, yes, yes. My lord, therefore, this court, my lord, earlier 2, 3 litigations were there, my lord. I have annexed one order,
Page 23.
page 23.
What was the direction here?
My lord, the relevant part may be seen page 26.
Yes.
Second, third para, my lord. May I read, my?
Yes, please.
After considering the entire aspect of the matter, it is found that the Director of Elementary Education, Assam, issued the impugned order dated 30/10/2015 for release of monthly salary to the respondent number 8 in pursuance of the order dated so passed by the court in writ petition number so. As such, the director concerned has not committed any illegal. It is about the area salary of the respondent number 8, my lord, in my case, which was preferred by the petitioner. It can be seen that the direction of the court not to provincialize one post of regular teacher in the ME Madrasa in question by ignoring the seniority of the teacher of the said madrasa, including that of the petitioner. My lord, I am the senior most teacher in that school.
Yes. Then?
Was only up to the decision to be taken by the DHC Dorong in terms of the order dated Chencho, passed in Chencho. And the DHC Dorong has already arrived at the decision in its meeting held on Chencho, which was approved by the said DHC and the DEO Dorong on 29/5/2015, have already forwarded the same to the Director of Elementary Education, Assam. Here, my lord, my name was recommended by the DHC, my lord. In view of the above, the court of is of the considered opinion that the petitioner failed to establish his case for issuance of any writ. Accordingly, this petition being devoid of merit is stand dismissed. However, it is made clear that the Director of Elementary Education Assam shall act upon the approved minutes and recommendation of DSC Dorong dated 28/4/2015 that was taken in pursuance of the order dated 15/5/2015 passed by this court in WBC number 2980/2013, which was forwarded to him by the DO Dorong on 29/5/2015 referred above, and the said director shall take necessary action forthwith in compliance with the said order dated 15/5/2014.
Where is
of
that
this
order
court.
15.5? Where is that order?
That order, my lord, I have not any. Yeah. Now, my lord, this court observed that as the petitioner's name has been recommended and forwarded by the DSC in terms of the court's order, that has to be complied with. Thereafter, my lord, the provincialization order of the petitioner has been issued, cancelling the earlier provincialization of Abu Talha Samsuddoha. Page
But
28.
essentially, your petition was dismissed. This petition 6974 was dismissed.
Dismissed in view of the recommendation. As the recommendation is forwarded, that's why court did not interfere. It was, my lord, kept open for the department, and department finally on page 28 cancelled the provincialization order of Samsuddoha
And appointed you.
and appointed me, my lord. Now, my lord,
In
page
July
29.
in July 2016.
My lord, page 29, kindly see, my lord.
Hmm.
My lord, I'm reading, my lord. In continuation of this office order, number so and so, my lord, this is the first provincialization order, my lord. The order whereby the school was provincialized. Report of the DO Dorong by letter number so and so, and provincialization order of this office memo number so and so, as well as honorable court order dated 2011/2015 passed in WBC number 6974/15. The services of the petitioner Suroj Ali, assistant teacher senior most of Besimari Girls MEM, is hereby provincialized in place of Abu Talha MD Samsuddoha, junior most, as per recommendation of District Scrutiny Committee and proposal submitted by the DO Dorong by letter mentioned above. Thereafter, my lord, all other terms and conditions of earlier order will remain same. That means, my lord, the provincialization order, my lord, the 2013 order, the all terms and conditions are remain same. That means, my lord, the order was passed giving effect 1/1/2015, 13, my lord. But may I invite, my lord, again to page 19, my lord. Page 19, my lord, can we see?
Yes.
In pursuance of the government letter number so and so dated so and so.
Where is the name of the school?
Name of the school, my lord, is 21.
Yes. Serial number?
Serial number 47, my lord. Besimari Girls
47.
MEM.
Yes.
Here, my lord, Abu Talha was provincialized. Serial number 2.
Your name was not there.
Yeah, my name was not there.
Very well. So
Now, my lord, the other terms and conditions remain same.
what was
That
the
means, my lord,
recommendation of the
effect
what was
was
the recommendation of the DLC, District Scrutiny Committee, DSC?
DSC recommended my 2015, my lord.
Recommended what?
Recommended for provincial.
Where is that recommendation?
My lord, they may bring. My
They
lord.
have everything. Quite right. So pursuant to this, in July, they have given you the appointment.
Yes, madam.
So where is the claim?
My lord, because my lord, I have been regularly serving in.
You may have been
school, my
serving, but you are not regular, you are not provincialized.
The post was sanctioned, my lord. In the sanctioned
Oh,
post, my
Mr.
lord.
Counsel.
Somebody else, my lord, who is not entitled, my
Not
lord.
entitled to, that is pursuant to the court's order. Where is the court's order saying that in the person whose provincialization was cancelled, you are to be appointed and your service was to be considered with effect from the date of the first regularization.
I'll bring those orders, my lord.
What orders?
The court's order, my lord. various,
We can find out the court orders, you give us the numbers. We are closing your petition. There is no claim, we are not entertaining your claim. Your claim is with effect from 2013 to 18.
Yes, ma'am.
You will get it
My
from,
lord.
when did he join?
I was since 1990.
When was he appointed? Provincialized 2016.
16, ma'am, July 16.
So from 16 to 18, he's entitled.
He's getting salary.
16
No,
to
no,
18.
no. Yeah, I have been getting, my lord, since 28, my lord, 1st March 2018. I have stated.
So he has to get it from 18 July.
That was also not given, my lord.
Mr. Pegu?
Yes, ma'am.
He has to get it from 18 July.
Page 7, para 4, my lord, I have it. My lord, may I
We'll
please?
come back at 2.
Yes, lord.
You find out he's to get it from the date of his provincialized service unless there is a finding that he was not working.
But he is claiming with effect from 1/1/2013, ma'am.
Very well, he's not available, but he is to be given salary from 2016, July 2016, provincialized scale.
Yes.
That you'll have to give him.
Yes.
So we dispose it off.
My lord.
All right, hard disposed.
My lord, may I place 2 orders, my lord?
Yes, please.
This honorable court, my lord, already observed, my lord, due to pendency of my lord cases, or my lord, due to oversight of the my lord department, if somebody left out for provincialization and if he is otherwise entitled for provincialization, my lord, he must be provincialized with effect from 1/1/2013. My lord, may I pass that order, my lord?
But the order must be reflected. The order does not reflect. You are not putting to challenge the 2016 order.
My lord,
Page number
4.
29. Page number 29 says.
Page number 29, my lord, last line, my lord, the other terms and conditions of the provincialization order remain same. My lord, in that school, my lord, other teachers, they have been getting salary with effect from 1/1/2013. The order, my lord, para 15, my lord, and 16.
You are referring to which paragraph of the judgment?
Para 15 and 16, my lord.
Para?
15 and 16. 1/5 and 1/6.
The person whose appointment was cancelled, was he working? Was he getting a salary or not?
Yes, my lord, he was
He
getting.
was getting.
Was it
my lord,
recovered?
till cancellation, he
Yes.
Was it recovered from him? Was
My
that
lord,
salary recovered from him?
No, my lord. How can I, my lord?
No, of course, not you. We are asking you whether there was any step to recover. That period of salary has already been paid to him.
Yes, yes. That has been paid, my lord, due to
Yeah.
mistake of the authority, my lord. What is my fault, my lord? Now, my lord, para 15, may I read, my lord?
Yes.
Court says, my lord, as the section 4(1), it says, my lord, the service of the petitioner has been provincialized, deemed provincialized, my lord. Therefore, my lord, he would get.
This is on a different footing.
Yes, ma'am.
This is on a different footing.
Yes.
Facts are different.
My lord, here the case is that the petitioner's case was pending before the court.
For the same post, if you want to claim the government cannot be penalized for releasing two sets of salaries. One to the person who was already working, he has got his salary. And you, because now you claim with effect from that, and which you are correct that it is not your fault.
My lord, post was one, and in that post, my lord, I was entitled for. But the department, my lord, wrongly, my lord, provincialized someone. Subsequently, my lord, they have rectified it by provincializing me. But the effect has been given when the post has been provincial against my lord. Oh, while my lord, the post has been sanctioned in the year 2013. And one last para, my lord, may I read, my lord. With the above observation, this writ petition stands allowed and the petitioner be provided with the benefits of provincialization from the date on which the Act of 2011 came into force, which is 1/1/2013. Here the background of the case is that, my lord, the petitioner's post was not regularized due to pendency of the court case. And
Yes.
another, this order has been, my lord, subsequently followed in another case, my lord.
All right. Are these judgments that you're relying on similar footings that some wrong other person was appointed and their appointments were subsequently cancelled? No. These are on the grounds that your recommendation was made, but because of the government's inability, the provincialization order could not be passed.
That's true, but my lord, whether section 41, my lord, of 2011 Act will not applicable for.
But your
in my
name was
case, my
never forwarded initially.
initially not forwarded.
Then you challenged the decision of the DSC. That was also dismissed.
DSC recommendation we did not challenge, my lord. Court says, my lord, as because the recommendation is pending, there is no
What was your
necessity.
claim before that court? What was your claim earlier?
There
What
were
was the claim?
several cases, my lord. Round of litigation were there, my lord. And I have not annexed all the.
No. In page number 23, what was your claim? Okay, heard disposed.
No.
Yes.
My father, he was employed as an upper division assistant, your lordship, at Narangi, in the ammunition depot of 99 APO, your lordship. Sometime in 86, an allegation was brought against him regarding defalcation of some money, your lordship. And an FIR was lost, and the case was instituted against him, your lordship. And the CJM, your lordship, that is, and immediately he was suspended, your lordship, after the filing of the FIR, your lordship. And on institution of the case, your lordship, before the CJM, the CJM passed an order, your lordship, convicting my father. That is at page 11, your lordship, relevant portion at page 22, your lordship. That is RI for 2 years, your lordship, and fine rupees 4,000. And that was an appeal was referred against that, your lordship, before the session judge, your lordship. And the session judge paused the order, your lordship, set aside the order. That is at page, your lordship, session court's order at relevant portion at 38, 39, your lordship. It starts from 34. That is order dated 27, 2000, your lordship. At page 38 and 39, your lordship. Let's see. At paragraph 15, your lordship, at page
Who for
38.
the respondent?
Yes, CGSC.
Where is CGSC? CGC. Who's for the respondent here? Who's for the CGC? Earlier, Mr. S.S. Roy appeared.
Oh, then lordship, he is in Ayodhya.
He is in?
Ayodhya, lordship. I've seen the pictures. So lordship,
Then please inform your DSGI to appoint somebody in his place. Somebody should appear.
lordship, then lordship, for today, lordship, some accommodation will be given.
All right, we are passing it over for the day.
And from the days level.
Please inform and let another counsel, if required, will appear. Or if Mr. Roy is back, then he will appear. So we'll fix the matter on Friday.
Friday next.
I'm sorry, on first of March.
Pleasure.
It is submitted that the CGC who was allotted the brief is out of station. Prayer is made on his behalf. Prayer made is not objected to by Mr. Sharma, learned counsel to the petition. Accordingly, list again on 1st of March.
Pleasure.
Wait, please, Lordship. Lordship, in this matter, I'm appearing for the respondent number 1, General Administration Department. Here, Lordship, unfortunately, our name has not been reflected in the cause list, nor have we been served any copy in this matter. So I have
Not served copies.
no,
So
Lordship,
we have served earlier.
only
to one and
finance.
two, most probably. left
2 and
out.
3, my lord.
2 and 3 we have served.
I am appearing for 1, so my lord.
Filed our affidavit also, Lordship.
Lordship, they have filed their affidavit. Respondent number 3 have filed their affidavit.
But the
What are your prayers here?
Lordship, I'm praying here for giving the benefit under the judgment order passed by the Honorable Division Bench in Upenda's case, Lordship. The matter here pertains to the regularization of casual worker, Lordship. He's a sweeper. working-
Pentas is not about regularization.
Not regular, Lordship, the directions under the, bringing the petition under the directions issued, Lordship, regarding the payment of salary and.
You are working under,
Department of Archives, Lordship.
who is the respondent? Number 3,
Lordship, respondent number 3 have filed their affidavit, Lordship.
your employer is respondent 3.
Yes, Lordship.
So what is the affidavit here?
Lordship, the financial sanction was up till February 2014, Lordship.
Hmm.
And thereafter, his extension was not done, Lordship. And this was sent to the SAD, Lordship, for further consideration, Lordship. So the SAD, they need
What
to
is
respond
SAD?
on this. Secretariat Administration Department, Lordship.
Respondent 1.
SCDS.
What have you done?
Lordship, actually, at this moment, I don't have the brief in the sense they have not served us any copy, so I'm not aware of the case.
Because
I've just been informed that we are in this matter, so the matter has been fixed.
finance concurrence was required, Lordship. So
I'll take a copy, Lordship, I'll get my
But
instructions.
is he working or not?
no,
Lordship,
Lordship.
he's working. He's working even today, Lordship. Even in the COVID period, he has rendered service, Lordship, and without any pay. Lordship. Lordship, his services were extended from time to time since 1994, Lordship. He's in the same department, working as.
When was the last extension?
Lordship, Lordship, one of the communication.
26/12/2013, Lordship, as per our affidavit. Thereafter, there was direction from this honorable court, Lordship, and thereafter it was taken to the Secretary Administrative Department, Lordship.
But Lordship, he has received his wages till 2016, Lordship. And after that, he is not getting his wages. 2016 till 2016, he has got his wages. One of the letter it comes evident, Lordship, page 50. One letter was issued by the director to the joint secretary. Page 50. Lordship of the writ petition.
So you are stated to be working till 2017.
Lordship. But I'm, even then also, Lordship, I'm working. It's not on letters, Lordship, but I'm working. Even today also, I'm working there. And in the COVID period also, I've rendered my service. And Lordship, the judgment, the directions of the judgment has been followed regarding the casual workers, Lordship, and accordingly, the finance department has taken steps. I have annexed those communications at page 72, 73, Lordship, 72, 72, 73, and 74.
Okay, Mr. Fukan, we permit you to obtain your instructions here and find out what is the status. If he's working, then he should be paid his salaries.
I'll get my.
It is submitted by Mr. A. Fukan, Learned Counsel, appearing on behalf of respondent number 1, that their names were not reflected, shown in the cause list, and that apart, extra copies have not been furnished.
No, madam.
Stop, and he therefore prays for further time. He therefore submits that the extra copy be directed to be furnished and he be permitted some time to obtain the instructions. MSM Bhattacharjee, appearing for respondent 2 and 3, submits that an affidavit has already been filed, whereby wherein it is stated that for the period his service petitioner services was extended, i.e. Twenty
26 to
26
2009.
2013.
Up to 26/12/2013.
He was working and whatever salary was required has already been released. Pursuant to that, the petitioner was not working under the respondent number 3. The said averments and submissions are denied by the learned counsel to the petitioner, who has relied on the affidavit in reply, filed in response to the affidavit in opposition filed by respondents 2 and 3. Mr. Fukan will apprise the court as to the status of the employment of the writ petitioner and whether any area salary is required to be paid to him. Matter is directed to be listed again on 1st of February,
1st of March.
1st of March.
Lordship.
Registry maybe has to be reflected our name.
We are fixing a date. You note it down if the registry doesn't reflect the date.
Our name can be reflected. Our names are not real.
Even if the names are not reflected, we are passing this order in your presence. It is listed on 1st. We'll have it on 4th of March.
4th of March.
And you serve a copy within this week. Names of all respondent or names of all councils, including respondent councils, will be reflected by the registry in the course list.
May it please your lordship.
Lordship, the subject matter of challenge in this writ petition is, my lord, the impugned order dated 30/7/2022, my lord. Page number 25, my lord, and it said D, my lord. Whereby, my lord, the respondents have cancelled the regularization order dated 14/7/2022, my lord, Annexure F, which was issued in favor of the petitioner, my lord, stating that when she was appointed, my lord, at that point of time, she was a minor.
Yes.
My lord, petitioner has already completed 23 years of service under the respondents, my lord.
Where is your birth certificate?
Birth certificate is not annexed to the petition, my lord, but Annexure G reflects the date of birth of the petitioner.
Annexure G is not by a government authority. What is Annexure G? Sorry.
Impugned order, my lord, whereby the
So this is what you are challenging.
yes, ma'am.
Then,
This is the subject matter of challenge.
then what are we supposed to do?
My lord, she
We'll uphold
applied
this
for the
order.
benefit of regularization, my lord.
We'll uphold this order and dismiss your petition. Unless you want to argue and say that this is incorrect.
Yes, my lord. In that regard, I would like to submit one thing, my lord.
Hmm.
After rendering so many years of service under the respondent, my lord, how they can do this to the
Because you're a minor.
at that time they may have looked
Uh-huh. So your appointment was,
just 25
but
years.
you do not dispute that you are a minor. Do you dispute?
No, my lord.
You accept that you are a minor.
Yes, my lord.
Then
My lord, just 25 days, my lord. He was 17 years, 11 months, 5 days old, my lord, at the time of appointment, my lord. And she has already given 23 years of successful service to the respondent.
what do you say, Mr.
My lord,
Counsel?
he is not qualified to be appointed at that point of time.
At that point in time. So how were you appointed by process of selection?
No, my lord. Due selection and the interview by Subdivisional Elementary Education Advisory Board, my lord. My lord, appointment letter is Annexed A, my lord. Annexed A is the appointment letter, my lord.
This 99 appointments, all those appointments were terminated, my lord. Subsequently reinstated following
Reinstated again, my
a
lord.
decision of the EC,
Thereafter,
the
she is
BTR government.
receiving her salary, my lord, regular salary, my lord, and she is continuing in her post, my lord.
They were reinstated because there was no notice served. Pursuant to courts of.
Reinstated following a policy decision of the BTR government. Otherwise, my lord, in read appeal also
Then why was she terminated again?
after scrutiny, it was found, my lord.
My lord, she is not terminated now, my lord. She is working, my lord, but regularization order which was issued in favor of her, my lord, has been cancelled by the impugned order, my lord.
Regularization order.
Within a month, they have cancelled the regularization order.
Yes, what do you submit, Mr. Counsel for BTC?
Perhaps I may be allowed to take some instruction, my lord, or file a affidavit.
Okay. Heard learned counsel for parties at the request of Mr. S. Rava, S.R. Rava, the counsel for the BTC, who prays that he be granted some time to complete his instructions. Matter is listed, to be directed to be listed after 4 weeks.
I am deeply obliged, my lord.
May it please your lordship. My lord, this matter relating to, my lord, the pay scale, my grade pay. Because after amalgamation of this school, my lord, three schools, one is high school and two, my lord, LP school and the ME school were amalgamated with the, along with this high school. My lord, at page 18 of the Annexure 1 is the order. The respondent number 5, my lord, he was a teacher of the ME school, and now he is, my lord, without creation of the post of assistant headmaster, he is drawing more pay scale than this petitioner. And, my lord, one allegation is this, my lord, the respondent number 5 should have, my lord, B.Ed degree, but it is not a proper and valid degree. So without this, my lord, how is drawing more pay scale than this petitioner, my lord? As petitioners are, my lord, assistant teacher having, my lord, B.Ed degree also, but they are drawing lesser pay scale.
You are
than this.
not claiming anything.
Yes.
You are affected by higher pay of private respondent. Yes.
Lordship, I am appearing behalf of Airware, respondent number 5.
Hmm. So
Kindly allow some time.
Let them file affidavit.
File affidavit.
Yes.
instead of that, why don't we send you to the department? Let the department make their inquiries and pass effective orders.
But, my lord, if
You are not claiming anything.
no,
Your
if
only
this-
grievance is that they are given a higher.
if our pay scale is, my lord, upgraded, we will be benefited. But, my lord, having lesser qualification than these petitioners.
That's what I'm saying. So your grievance is in respect of the private respondent. It's not a case that
Yes, yes.
the benefit given to private respondent should be given to you. That is not your claim.
No,
Is that
it is one claim is there, my lord. So if the same pay scale is upgraded, then, my lord, we have nothing to say. But without creation of the post, my lord, how is drawing higher pay scale?
yes, education,
And secondly, my lord,
no instruction.
Lordship, Lordship, we don't have instructions are awaited, your Lordship.
my lord, notice was issued lower back in February 2022, 23. my lord. 1 year.
You'll have to wait for a few more years. Yes, 4 weeks to complete the pleadings by the respondents in respect of the allegations made by the writ petitioner. Matter be listed after 4 weeks on a date to be fixed by the registry.
Registry.
Meanwhile, the pendency of the writ petition shall not be a bar to ameliorate the grievances raised by the writ petitioner.
Yes. Obliged.
Obliged, my lord.
Lordship, here in this matter, Lordship, I need some time to obtain my instruction, Lordship.
How much time?
Lordship, 2 weeks, Lordship.
Kindly check the date.
What is your grievance here?
Lordship, herein the petitioner is the widow of a assistant professor of Bhimaji Commerce College. He died in harness, your Lordship, and he died at the time of his death. He had less than 1 year of service left, your Lordship. So later on, after his death, money was recovered from him on account of wrong fixation of pay. But your Lordship, our claim is that we are not responsible for that wrong fixation of pay, and we are relying on the judgment of the Honorable Supreme Court and the notification of the government of Assam. Your Lordship. So, your Lordship had sought instructions as to whether we are at fault for that wrong fixation of
Mr. D. Upamanyu, Learned Counsel for Higher Education,
Yes, Lordship.
prays for further time to complete his instructions. Mr.
As they, my lord.
S.
They.
Day, Learned Counsel for the petitioner, submits that the matter be listed on a fixed date. List accordingly. On 12th of March.
Highly obliged.
Much obliged.
May it please your lordship. My lord, I had filed my affidavit on 12/1/2024, my lord, whereby, my lord, the petitioner name, including other 24 employees, my lord, retired employees, name has been sent for supplementary demand, my lord. And today I have received instructions that government has not sanctioned the supplementary demand, my lord. So I need 1 week time, my lord. Further instruction I will.
Government has rejected.
Yes, my lord. That is my as per telephonic instruction, my lord.
MSRS Deori Learned Standing Council, Soil Conservation, submits that she has been verbally informed that the supplementary demand raised, demand proposal submitted by the department for payment of what? Area salary,
No, my lordship.
For granting aid, my lord.
for grants in aid.
Yes, my lord.
In
To
respect
the-
of this petition, it is leave encashment and gratuity, my lord.
For gratuity and leave encashment benefits in respect of the petitioner has been returned back to the government, to the department. Stop. She therefore prays for further time to complete the instructions in this regard.
My
Mr.
lordship, I have a prayer, my lord. Similarly situated matters were disposed of by this honorable court. I would like to place those orders also.
They have already examined and raised the supplementary demand. These orders are to examine your claims and pass appropriate orders.
My lordship, these petitioners have filed now contempt petitions. They are in the contempt stage.
Which petitioners?
These petitioners, the order I have placed, they have filed even contempt, my lordship.
My lord, those
Scenario is
contempt
In,
matters,
in your matter, they have filed an affidavit saying that they have raised the supplementary demand.
My lordship, they have specifically admitted that my claim, my lordship. So I am praying for disposal, my lordship.
That is right. So they have raised the supplementary demand for payment of the amount, which has been rejected by the government or returned back by the government. So let us have the instructions. Why was it rejected?
I'll leave it to your lord.
That will be listed after 3 weeks, enabling the respondent standing council to complete their instructions as to why the claims, the proposals for supplementary demand put up by the respondent department has been returned back by the competent authority in the government. Mr. So-and-so appears for the writ petition. Yes.
Obliged, ma'am.
The denial of area salary of the disease husband of the petitioner, my lord. My lord, kindly see page 14, my lord. Order of this honorable court, my lord, paragraph 9, my lord. And subparagraph the area salary. The area salary, my lord, proposal has been made several times by the DEO, Nogong, but till date, no action has been taken. Page 15 and 16, my lord. The proposal, my lord, sent by the DEO to the Director Elementary Education. From Director Elementary Education, sitting tight over the matter. And the husband of the petitioner retired on November 11, my lord. After 12 years, my lord, they have not done anything.
So after this order, what happened?
No, nothing,
Huh?
nothing. No.
You did not
Can
file a
you-
contempt.
I approached my lord because of COVID and other things, my lord. Filing of the content. Second, the bar.
There's no absolute bar. You have to convince that whatever reasons you could not.
No,
file the-
I filed a contempt petition.
Hmm.
His honorable court, my lord,
It was closed.
closed.
Where is that order?
Order I have not enclosed, my lord. But contempt petition number 343/23, my lord.
Yes, Mr. Pegu.
Justice.
I need some time after this.
Well, every time, my lord, things, my lord.
To
My lord may dispose of the matter and fixing a time to release my entitled salary.
So that this time you may file a contempt.
This time I file. Yes, my.
You get the instructions.
Yes, sir.
You get it. We'll take it up on a fixed date. You can tell us your dates.
My dates after 15, my lord.
After 15th. All right, we'll give you a date after 15th. 19th.
19.
Matter be listed on 19th, by which date the respondent, department's counsel, Mr. Pegu, will obtain instructions as to why the claims of the petitioner has not been considered in spite of a direction of this court passed in WPC number 83 of 2014 by the order dated 2209/2019.
Pending disposal, my lord, cannot be bar, my lord.
Yes, placed on 19th. Pendency of the writ petition will not be a bar to redress the claims of the writ petitioner.
May it please your lordship. Lordship, matter is pertaining to non-payment of regular pension, lordship. Lordship, petitioner was initially appointed as lordship Vistavinit lordship. Thereafter, lordship, she was deputed to undergo the
Yes,
petition.
again,
Yes.
no instructions.
Yes, my lord.
Lordship, one similar
I need-
situation matters already disposed, lordship, by your lordship.
Here, my lord, petitioner was received salary up to only 2012. But, thereafter,
why?
That instruction I had to contact. No.
Lordship, already lordship, your lordship has disposed one similar situation matter, lordship.
Take us through the facts. Facts of the case.
Yes, lordship. Lordship, in the year, lordship, 1995, lordship, annexure 1, lordship, page 22, lordship. Petitioner was appointed as a lordship Vistavinit lordship. Thereafter, lordship, in the year 2000, she was deputed to lordship
Junior
basic training, lordship. Annexure 2, page 24, lordship. Her birth certificate, lordship. Thereafter, lordship, annexure 3, lordship. Page number 25, lordship. After qualifying the junior basic training, she was allowed to do the regular scale of pay, lordship. Thereafter, lordship, service book was also open, and she was also GPF account number was also allotted to the petitioner, lordship.
Then,
lordship, in the year, lordship, she has been regularly receiving her lordship salary since March 2012, lordship. Thereafter, she has not received any salary, lordship. And lordship, page 44/5, lordship, she was retired from service on 5/5/2022, lordship.
no, we'll have to get instructions. Why
Yes,
you did not receive salary?
Yes, ma'am.
Lordship, in this regard, lordship, I have instruction that regarding lordship area salary. I'm not was instructed to not press, lordship. Regarding lordship area salary, I'm not pressing, lordship. Only regular pension part, lordship. Yes, Your Lordship, I am praying for the similar order also.
Okay, you verify and then find out. Otherwise, stipendiary teacher.
Yes, my lord. My lord, I need some time.
No, we are disposing it off in terms of this order. You verify. If available, you make the payments. We are recording that she is not claiming the area salary.
Yes.
Yes.
Disposed. No claims for area salary.
Entitled, my lord. She will get the pension. If entitled. after
If
verification.
entitled, yes. After verification, if entitled. Yes, disposed.
Yeah, please, Your Lordship. Affidavit in reply has been filed on 6/2. We have served the copy today, Lordship. Because inadvertently it was not served on the PWD. But matter will be taken after 10 days, Lordship.
It is submitted that a copy of the reply affidavit could not be served to the respondent counsel, and in the course of the day it was served. Therefore, learned counsel for the petitioner fairly submits that the matter be taken up on another date. MS M. Das, learned counsel for the PWD, submits that she would like to complete her instructions in respect of the affidavit in reply filed. Accordingly, matter be listed after 2 weeks.
May I pray for a date, Lord?
18. 18 March. Huh?
May I please, Your Lordship. My lord, in this case, in a departmental proceeding, my lord, punishment of dismissal. So, my lord, in this case, affidavit in opposition is required.
Lordship, we have received our instruction, Lordship, and activities are pending, Lordship.
You are challenging the dismissal termination order.
Yes, ma'am.
Any appeal file?
Appeal file. That was rejected.
Appeal, Lordship.
You file your affidavit if you want, and records are also necessary.
Yes, ma'am. Let the record be called for.
Lordship, by this week we will file, Lordship.
Heard and counsel will issue rule, then it has to be
Yes,
heard.
ma'am.
Issue rule. Call for the records. The respondents are at liberty to file their affidavit in the meantime. Matter be listed after 4 weeks.
Yes, obliged.
Yes, Lordship.
My lord, here is some accommodation needed.
No instruction.
Yes.
Mr. Pegu, learned counsel for the elementary.
Yes, sir.
Submits further time is required for completing his instructions. Mr. M. Islam, learned counsel for the petitioner, submits that the interim protection be extended. Accordingly, matter be listed after 6 weeks.
Yes.
6 weeks?
Right.
6 weeks. Interim order will continue.
Bless.
And until the next date fixed. List on 8th of April.
May I please, Your Lordship? Here, Your Lordship, affidavit is almost ready, Your Lordship, but the annexure part, Your Lordship, that doesn't provide to us, Your Lordship. Regarding that, Your Lordship, we had made communication.
How much time do you require?
1 week.
1 week further time is prayed for by the Learned Standing Council.
I'm
Or-
appearing on behalf of PNIF, SSA. Respondent
Appearing-
3.
Council appearing on behalf of SSA for filing the necessary affidavit. Prayer made is not objected to. Matter be listed after 10 days on a date to be fixed by the registry.
May I pray for fixing?
The registry will fix a date, letter file. Their affidavit has to be filed. You may like to reply. So what is the point? Okay?
Deeply obliged.
Please, your lordship.
Covered?
My lord, I have gone through that order, my lord. Register Niyog, my lord. Register Niyog, my lord, as lordship directed to me. But after going through the judgment, I found some little different here, my lord. Because, my lord, in that case, my lord, board of director appointed my lord. And thereafter, my lord, by taking resolution, board of director, my lord, have taken the action, my lord. But in my case, my lord, from the documents, my lord, register has passed the order of my appointment. Thereafter, in charge registered, my lord, had also, my lord, some order regarding my lord charge, and thereafter, my lord, taking over the charge.
So the question is not who has passed the order. The question is what is the status of your employment? Are you an employee under the registrar's office or you're an employee of the cooperative society?
But earlier, I was a salesman under the society,
Hmm?
under the cooperative society.
Then, so if it is a cooperative society, then
Petitioner doesn't.
is there an appellate forum?
My lord, and another, my lord, the
Appellate forum, yes, your
suspension
lordship,
order.
because section 111 of the cooperative society, he can approach the registrar, your lordship.
So my humble that prayer,
What?
because, my lord, that order also, my lord, not as per law, my lord, that is suspension order. It is passed by a secretary, my lord. But had it been passed by the board of director, my lord, or board, it would be
Where is the impugned order?
last may kindly see page 13.
13, your lordship. Lordship, in pursuance to the
This
decision
is the
of
direction of the board,
Yes,
board
your lordship.
decision.
Board
You are
has
only
taken a decision,
communicating
your
it.
But secretary has.
Secretary has communicated, that's his
Yes.
job
Otherwise, decision has been taken by the board, your lordship.
by the board.
So, my
Where
lord,
is the provision for appeal?
111.
111 is
And in their affidavit, they also stated, my lord, ultimately the my lord, register will after.
But otherwise, his suspension order has been passed by the board, your lordship, and in that case, board has to take a final decision. Appeals or review section 111, your lordship.
I recollect a similar matter where I think your colleague, Mr. Talukdar, had appeared. Is he still standing counsel?
Yes, your lordship.
Please
My lord,
can you
another
inform
order,
him. I think there is some order.
lordship, page 12, my lord. My lord, taking over of charge also, I have made impugn in this petition, my lord, which was passed by the assistant registrar.
You inform Mr. Talukdar. I think he may have that order.
Lordship.
So we'll keep it on.
Lordship may dispose of the matter, directing the registrar, my lord, to take a decision on this matter.
Why?
Because your lordship, 2014 suspension order by now.
That is invoking our jurisdiction. I think we need to find out whether we should at all invoke our jurisdiction. For what
Yes.
purpose?
Yes, your lordship.
But this matter, page 12, that order was passed
And by now, your lordship, I think the board's term has also been over and new board might have been formed, your lordship.
Yes.
And I have approached before these are on 17, my lord.
May have approached. Who is for the cooperative society?
Here
The
he has made
particular.
party secretary and the chairman, but I think no one has.
Where
represented.
is the? Have you taken steps?
Yes, my lord.
Respondent number 6 and 7 is the secretary and chairman, your lordship.
Yes, my lord. So far, I remember, my lord, service.
You find out from the registrar's office what is the status of the cooperative society. As on-
Present board,
as on date.
Lordship,
And you also inform Mr. Talukdar on the next date,
Lordship,
so that if he may have that copy of the order or judgment. Matter be listed again on 4th March.
Of that.
Alright, by which date the respondent counsel, Mr. Bordoloi, will obtain instructions with regard to the status of the cooperative society as on today, and the whether the status of the cooperative society along with the present board of directors. Stop. Let the matter be listed on 4th. We are not putting it in order. You can inform Mr. Talukdar.
Lordship.
All
Of
right.
that.
Yes, Mr. Das. 3 weeks' time.
Lordship,
And also even there on 15/3 also there is a specific order.
Lordship, may I pray your lordship? Lordship, I pray for some accommodation, your lordship.
The court has given you accommodation
Lordship.
since 15th of March,
Lordship,
2022.
Lordship, our difficulty is that, Lordship, the file is untraceable, your lordship. We have to reconstruct it. Instructions are here, your lordship. We have received the instructions.
What instructions?
Lordship, on his, because his demand is allowance, your lordship.
Hmm?
Regarding allowance, your lordship. And there is also an interim order, your lordship, to that effect. House allowance, your lordship.
The interim order was only in respect to recovery.
Why is it come for orders?
So earlier it was listed for admission. We have services complete in respect of respondent number 5 long back. There was already order passed by this Lojima court. And the respondent number 5 has already retired from service. Our grievance is with regard to the lordship order passed by the director.
Where is that impugned order?
Lordship page 15, annexer P2.
What file is missing?
Lordship, the writ petition, your lordship.
Huh?
The writ petition, your lordship.
Writ petition, how long does it take to reconstruct the file?
Lordship. Lordship, we have to get a copy of it because without that copy, we will not be able to file the
Second copy is there, this copy is there, you apply for certified copies?
lordship.
What stops the secondary education to apply for certified copies of the pleadings? Why should you keep furnishing copies after copies? It is submitted by Learned Standing Council that the copy of the brief in respect of the matter has been misplaced, and therefore she prays for further time to reconstruct the brief. Mr. S.K. Das, Learned Counsel for the petitioner, submits that several opportunities were granted. However, no affidavit has been filed. Stop. Considering the submissions made by the Standing Council for the ends of justice, the matter stands adjourned for 4 weeks. The respondents may apply for certified copies of the pleadings felt necessary to reconstruct the brief in respect of the department. Interim order passed earlier will continue until further orders.
Obliged.
My senior is suffering from fever and some other problem. So kindly fix the matter on next month.
Who's your senior?
R.K. Malakar.
It is submitted on behalf of Mr. R.K. Malakar that the learned counsel is indisposed, and therefore prayer is made for adjournment of the matter for 2 weeks. Accordingly, matter stands adjourned for 2 weeks to be listed on a date to be fixed by the registry.
Hearing item 50.
Maybe little. This is the hearing matter, my lord, 2016 matter, my lord. But unfortunately, they have given the affidavit on today, my affidavit of opposition, my
Mr.
S. Rahman.
S. Roman, learned counsel for the petitioner, submits that the respondents have served a copy of the affidavit. Have you filed it?
Lordship. Just
Today, in the course of the day, during the course of the day. He therefore submits that sometime it would be necessary to complete the instructions in respect of the said writ petition. Mr. R.M. Das, learned counsel, appears for the respondent and submits that the affidavit has been filed today. Accordingly, matter be listed after how much time? 3 weeks. After 2 weeks. List after 2 weeks. Tomato. Itu kata.